Bene, buongiorno.
Good morning. I'd like to welcome everybody to this workshop. Obviously a special welcome to the authorities, and particularly Deputy Minister Katrikala, who honors us with his presence and his interest in this topic. I wish to obviously and very warmly thank the Chamber of Deputies and the presiding officer of the Chamber of Deputies, who hosts us in this splendid hall. And I would like to begin our meeting with just a very short introduction. I'm not going to inflict a lengthy speech on you. We're here to discuss a very important topic, and also a very complex topic. Piracy and intellectual copyright on the internet constitute complex issues because they comprise a number of issues which are in themselves complex. The authority, AGCOM, is convinced that the first thing to be addressed in order to deal with this problem is awareness and education. It means that we have to inform people and train people, young people, to abide by the laws in the use of digital content. And therefore, isn't it too loud, you say? We wish, first of all, to educate users and as citizens, and in this effort to educate people, we would like to be assisted by everyone who can. And another thing is to provide a legal supply of resources on the network, which can be attractive, and which also in terms of the time of use. And finally, we have the enforcement area, which is something which has attracted interest and discussion clearly. From this point of view, any action has to occur within the terms of reference and the powers which are accorded by current laws. Our viewpoint, the viewpoint of AGCOM, in considering, as I said, this very complex set of issues, it's complex from a technical and from an ethical standpoint, is to promote the development of a content market which is open, which is legal, and where everyone can operate on an equal footing, with the prospect for everybody to draw advantages from them, whether they're copyright holders or whether they're service providers, or, and obviously, last but not least, the final users, the customers and consumers. AGCOM is looking into these issues with great attention, and is also considering the critical points for any action. There are a number of critical points, but these can be analyzed, and we can, I believe, address them. The relationship between copyright and intellectual property rights and other rights, the relationship between the various operators and actors involved, and the preparation of alternative technical solutions. Now, when we speak of protecting intellectual property rights as part of fundamental rights, there are some people who feel that there is a conflict between the freedom of expression and intellectual property rights, whereas we are convinced that both of these are basic rights on the basis of Articles 11 and 17 of the European Union's Charter of Fundamental Rights, and therefore their protection has to be provided within the principle of legality, reasonability and proportionality. Obviously, I think we all are aware of this, that if Parliament were to decide to undertake a reform of the law to protect copyright, in order to adapt it to the current to recent developments, the authority would be very glad to leave responsibility to Parliament and to leave decisions on action to the legislative branch. In the current regulations, the ICOM believes that it is essential to analyze the situation thoroughly. We believe that the current provisions give us this power. Our predecessors had prepared a draft which was discussed, which was taken for consultation, and which was the subject of considerable debate. A number of critical points were identified within it. The possible absence of a regulatory and legislative basis, the effects of the enforcement, rules of enforcement compared with those in other countries such as the French law, and the consequences which might derive from the analysis of data on the economic impact of piracy, analyzed both in terms of complementarity and replaceability of legal content and pirated content. Now, a lot of times elapsed since then. There's been a lot of new research which has been carried out, and obviously we intend to take it all into account.
Giuridici, l'autorità.
On these legal aspects, the authority is consulting a number of eminent legal experts who have from various areas and with various outlooks, to ask them to establish whether there is a legal basis for the rules which have been indicated and what they believe should be done. We're also undertaking a thorough internal analysis, and we believe that as part of this process, this workshop, where we have a number of experts from Italy and from abroad present, we have a international lineup for our initial sessions, and we believe that this is very important in order to collect further data which we can process in order to reach the best possible solution. So we intend to do by learning. As we learn, we intend to move forward, analyzing all the economic data, recent legal developments, and therefore make a very close assessment of all the options which are proportional and effective in order to establish a system of regulation which is in line with the community legislation and regulations and the most recent international developments in the area. Within this framework, we are open to any exchange and discussion, as long as it is constructive in nature, as long as it is without initial prejudice and directed to finding a common solution. And on the basis of this spirit of open and constructive discussion, I wish to express my hopes that this will be a very positive and fruitful meeting. And in fact, I'm sure that this day will be a very useful and interesting opportunity for discussion for everybody, and I'm sure that the authority, we will learn a great deal from what is said here today.
A questo punto mi ho piacere ed onore introdurre la prima discussione della mattinata.
To introduce the first panel of this morning, and we will hear from Ms. Kirsten Jorna, who is the director at the DG Internal Market and Services at the EU Commission. I can't say that she's an old friend because the adjective old sounds bad, but we've known each other for many years indeed, and we've worked together quite a lot. So a very young but long-time friend. And she will be followed by Mr. Stanford McCoy, who is a U.S. Trade he's the Assistant U.S. Trade Representative for Intellectual Property and Innovation, who will share with us the perspective of the United States. At this point, I'd like to give the floor to Kirsten.
Thank you very much, Minister, Chairman, dear Angelo. I'm very pleased and thankful to be able to contribute to the discussions today. And because I have an introductory keynote, I would like to do some scene setting. The prologue. The title is interesting. Copyright and Internet. Today, people associate extreme opposites. And Angelo, you referred to that with regard to some debates you had in Italy. It's either or, life or death, freedom or censorship, tragedy or comedy. I would like to reflect on this issue with you today from 3 different angles. What is the Internet for citizens? What is the Internet for authors, publishers, musicians, artists, film producers? And what is the Internet for the regulator, which will take us to the core issue. In the course of my reflections, I will take you into the living rooms of European citizens. I will also propose to you a little excursion on the innovator's trail, and I will invite you to follow the money. Now, what is the Internet for citizens? It's first and foremost a formidable basis for information, but also an ever-growing source for enjoying music, films, literature. The world in my living room. Every European citizen listens on average 2 hours per day to music. That's 40 tracks per day, roughly. There's an increased reading and publication of e-books. 90% of all the books published in a number of member states today are published parallel in their e-version. Even if the markets in Europe do not grow yet as the markets in the US, where e-books already are 6% of the book market and growing fast. The same is true for the United Kingdom. The digital consumption of audiovisual media has taken a huge leap. digital media. Sorry. For example, a German news site called Welt.de. Okay. Doubled the number of visitors between 2009 and 2011 to take it monthly to 7.6 million. That's a tenth of the population in Germany. So much for the living room. What is the internet to musicians, authors, actors, film producers and publishers? It's first and foremost a new and very exciting means of distribution of content to new and different audiences in a single market of 500 million citizens. In a continent of soon 28 countries, music and images are the common language. More than 200 digital music platforms provide services in Europe. More than 30 million tracks. Globally, 30% of music sales today already are digital. There's also a growing number of new video-on-demand services. It's a four-digit growth. It represents still a minor part of the consumption, 1%. But this is of course true because there is still a very strong TV consumption. On average, European citizens watch 228 minutes per day into the little box. And then there's the book market, which I already mentioned, which is growing. Now, what challenges does the internet pose for the legislator? Of course, our discussions focus on copyright today, but I want to zoom out for a second to intellectual property in general. My commissioner is Michel Barnier, and he's the successor of Mario Monti on this file for the single market and the responsibilities for intellectual property. Michel Barnier's starting point is the innovator's trail. Just in a nutshell, innovation starts with an idea. Once the idea is crystallized, you need a title, a copyright, a patent, a trademark. And once you have the title, it's not more than a piece of paper, but you need money to develop it. And the title should be strong enough for you to get the money and develop it. Develop the artist, make the film, or develop your invention. So it's money. Idea, title, money. Once you've developed it, you want to make money with it because you want to get the money back. You have to pay your loans. What you need here is a legal environment that allows you to make transactions, to actually license what you've produced. And because, by definition, your idea was successful, you will need to be aware that there will be copycats who think they can take a shortcut, and you will need to be able to enforce what you have to protect your property. And finally, if your product, your idea is a real success, you will want to export it, and you will expect your government, Europe, to help you do that and at the same time protect you. So the innovator's trail is idea, title, money, transaction, enforcement, international. We believe that the legislator must ensure that the right legislation is in place that facilitate the innovation trail at every stage and helps to create jobs in Europe. Now, what does this mean for copyright? And I'm going through the innovation trail. The title. Copyright, for the time being, is a hotly debated issue. And we believe that we have to look at the existing laws, in particular our directive from 2001, to see whether the rules are still the right ones, whether they strike the right balance, whether they create innovation, whether they create jobs and are not an obstacle. We haven't decided yet. The Commission is conducting a number of studies, both legal and economic, and I would like to stress economic, to see how the current rules operate in the new emerging markets and how that impacts on business models. We will probably come out with the results of these studies in 2014, and the Commission in last December said that they would then decide whether to take action forward, specifically legislative. That was the title. The next stage was money. How can we make sure that ideas can turn into innovation, and that from the point of view of the idea, they can cross what many people call the valley of death to find money and be developed. Michel Barnier proposed legislation in the beginning of the mandate on venture capital funds, because there's too little venture capital in Europe. And we proposed legislation that was recently adopted that venture capital funds can collect money and invest in every single member state on the basis of one authorization rather than 27. We're also looking into micropayments, because today, as I said, citizens, all European citizens, on average, consume 40 tracks of music per day, which they want to pay for. But today, the payment systems do not really allow these micropayments. They are starting to, but today micropayments are still often more expensive than the object you are trying to buy. We had a green paper on micropayments, because that's also in Michel Barnier's, as Angelo will remember. It's also in the internal market portfolio, and we are trying to develop new methods where also young people can easily pay, which brings me to the next thing, again money, pocket money. Today you can only pay essentially on the internet if you have a credit card. Who has a credit card before the age of 18? It's the parents' credit card, and for some reasons, and I'm a parent of 4, there's a certain reticence in giving your credit card. But it means that young people have difficulty to access the music they want, even if they want to pay money. Next step was transaction. We need a legal environment that makes it possible in all legal security to license. And as far as copyright is concerned, there are some concerns. The first is collective management. On the internet, and music is the prime example, and I talked about 30 million tracks, it's mass consumption. And for mass consumption, you cannot imagine individual licensing. That's unpractical. So what you need is intermediaries. Europe boasts of the best intermediary system in the world for copyright, which is the collecting societies. This is very much developed in Europe, not so much in other continents. And that's a very good basis. But collecting societies, they were used to dealing at national level and not across borders. There was a problem, there was a bottleneck. And therefore we presented legislation to have common rules of the game for collecting societies. They are in the last stages of the legislative debate, and we hope these rules to be adopted before the end of the year. We also have another exercise which is not legislative, where we try to see how licenses and licensing, innovative licensing, can solve some of the pain points that citizens often complain about. For example, user-generated content. Why, if I upload my baby dancing and I have some music in the background, am I being pursued? What's the problem? I didn't even know. Or the creative, I'm sending little videos to my friends. All these issues, this is user-generated content. Another issue is portability of subscriptions. Why can I watch this film when I'm in Italy, and when I'm on holiday in Greece, I can't? Why? So we have identified 4 pain points, and which are user-generated content, which are portability of subscriptions, my Spotify, in inverted commas, the availability of audiovisual content on the internet, and text and data mining. And we've asked stakeholders to get together around these 4 points and try to find solutions themselves. Contractual, licensing, and I only mentioned one on user-generated content, for example. There are models around YouTube today where YouTube makes a license with the right owners, and that creates a safe harbor for the users. An example. And we are expecting the stakeholders to come up with solutions, contractual or technological, that's also a possibility, by the end of the year. It's licensing. I now come to the next stage, which probably will be the focus of our discussion, enforcement. I said when I presented the innovation trail, that it's very important to be able to tackle free riders, because they take away the return that you need to recoup your investment. Now, already free riders are often, almost always, one step ahead. Already the Romans, and I don't mean you, but 2,000 years ago, complained about fake urns. The first thing about piracy and counterfeiting, about free riding, is awareness, like Angelo has said. And I would like to announce that we're conducting a very broad awareness study at the moment, which will be like an Eurobarometer, but larger, on the awareness that citizens have of intellectual property, copyright, but also patents and trademarks. And that result is to be expected, but before the summer. It will legislators across Europe and governments an idea what citizens actually know and expect also from their governments in these areas, and I think it will help us to develop the best policies. Then there is also litigation. All national laws provide for litigation and damages, but that's a cure. It's often lengthy, often expensive, and always after the milk has been spilled. We recently conducted a very broad survey on national civil enforcement measures. And there were quite some interesting findings. The first was to litigate or not to litigate. Many respondents indicated too long and too expensive procedures, a low likelihood of being compensated at the end of the proceedings, and a low likelihood of successfully providing the infringement to the required standard. They often complained also about the lack of courts and judges specialized in the field, the limited effectiveness of remedies, and the requirement to incur expensive guarantees while seeking an injunction. So it was better not to litigate, in particular if you're an SME. Second point of criticism was the cost of the proceedings. Proceeding IPR in regard to other infringements is relatively high, and because the matters often are complex. It can range from 1,000 euro to several thousand euros per case, and they differ significantly among member states. If I may say so, the more accessible member states are Portugal, Romania, and the Czech Republic. One of the most extensive member states in that regard, as far on the basis of the survey, is Germany. Then there was also a point about the length of proceedings. It depends on the jurisdiction and the remedy sought, but it can be concluded that the average time of court proceedings varies from less than 2 years, that's the best, to 3 to 5 years. In the group of the best, the Netherlands, the UK, and Germany. In the more lengthy, Italy, Spain, and Hungary. And again, this acts, if you look at who responded what, it acts on the decision, in particular of smaller companies, not to litigate. In terms of legislation, we have been looking in a more broader sense on illegal content, not only illegal from a copyright point of view, but other defamation, child health. And we're preparing an initiative which is called Notice and Action, and where we will seek to harmonize to some extent the procedures for notifying and taking action across Europe, so that operators and also those who claim infringement have a one route, a single route to raise these concerns. And this procedure will include a notification, transparency, and a rebuttal stage and a takedown. We are still working on this legislation, but we expect it to be presented in the course of this year. Now, that's concerning the milk has been spilled. We have another approach on which we work very intensively now, and that's follow the money. That's a stakeholder process. Free riding today is a successful business model because, to some extent, it meets consumer demand. Remember my pocket money issue in an emerging market. But it is also treated by platforms, payment services, and advertising companies as a respectable business partner when it comes to payments to be made for counterfeited goods and pirated music or films on the internet, or when it comes to advertising on the internet. Free riding websites are accepted by companies that seek to maximize their advertising impact for advertising purposes. Why? Because the currency for their contracts with the advertising industries are clicks. And experience tells us that most clicks are on the pirate or counterfeit websites. There is today what I'd call a tendre insouciance on the part of companies when it comes to the use of their advertising budgets. And for fun, when we're seeing companies that complain heavily about counterfeiting, we trail them on the internet and we look where their advertising is. And in almost every single case, we find that advertising for this particular company is also taking place on rogue websites. So I think there is a real issue for companies to consider and be more demanding where their advertising is placed when they make these contracts. We have a memorandum of understanding which is functioning fine for the sale of counterfeited goods on the internet. And this memorandum is based on notification and action between the partners of this memorandum. For the time being, it's platforms and brand companies. But what we are trying to do is to extend this both in scope to cover other areas of infringements and in terms of stakeholders to include the advertising industry and the payment services. Because we believe if you starve the rogue websites, if you starve the business model of free riding by starving their financing, they will disappear. And it's an intervention at that level rather than at the level of the individual citizen. And I hope that also this conference will help us to convince a number of companies to be more precise when it comes to spending their advertising budget. I would like to conclude with our vision for copyright. We cannot give free rein to the illusion that everything is free. Nor can we give the impression that in an age where file duplication is instant and infinite, unlimited sharing of protected content is covered by a kind of digital natural law, particularly when the objective is profit. But in order to be heard in these matters, we must also be better able to demonstrate the crucial importance of an effective and efficient intellectual property system for the vitality of our societies and of our companies, and for jobs. We're actively working on this, and so are other governments, but I think we also have to call upon the actors in the cultural sector and the creative industries to share our ambitions, to be partner to operations like Licenses for Europe, to be partner in stakeholder agreements around notice and action. I come to the epilogue. I have exhausted you. We've covered quite some terrain. Copyright and internet are not a contradiction. They are the two sides of the same coin. They are a great opportunity for human enrichment and the European public space across language barriers. Thank you very much for your attention.
Ok. Problemi di comunicazione, non
Communication problems, but not telecommunication problems. I would like to thank Kirsten, first of all, for an extremely interesting presentation, which covered a large part of the ground which we wanted to discuss today, from a very authoritative and highly informed standpoint. I'd also like to thank you for having kept to time so exactly. And now I'd like to give the floor to Stanford McCoy, who is Assistant U.S. Trade Representative for Intellectual Property and Innovation, who will be giving us the U.S. viewpoint, the U.S. being another major actor in this area. Mr. McCoy, you have the floor, sir.
Thank you very much, Mr. Chairman, and to all of you, I really welcome the opportunity to be here today. Of course, it's never difficult to accept an invitation to come and speak in Italy. I'm particularly grateful to the Chairman, to all the members of the Commission, to Commissioner Decina and Commissioner Preto, who took some time to meet with me during my last visit, and to all of you working for EDGCOM, who have put so much work into efforts of copyright protection in the digital environment. I'm very grateful for the opportunity to be here and talk with you today, and also grateful from the standpoint of the broader United States-Italy trade relationship, which is something that is incredibly important to us in the United States from multiple different perspectives. Of course, its economic benefit, but we also remember that in the United States, we are a nation of immigrants from many different parts of the world. There are 18 million Americans who claim Italian heritage, and so I bring you greetings from them. You might guess from my name that I'm not one of them, but I will tell you that I am one of a much smaller group of Americans who still drive Alfa Romeo automobiles that were imported into the United States in the 1980s, and my mechanic and I have been quietly waiting for the return of Alfa Romeo to the United States for many, many years. I understand it's coming soon. So I have a deep affinity for Italy and all things Italian, as do many, many Americans. And it's from that perspective, among others, that we look forward to engaging with Europe and with the member states of the European Union to create a transatlantic trade and investment partnership that will more closely bind together the United States, Italy, and the nations of Europe in what is already the world's biggest and most vibrant trade relationship, and we will make it deeper and broader. I want to focus this morning on one aspect of that trade relationship, which is the protection of the value that we add to goods and services through intellectual property rights. And this is, of course, a critically important component in both the U.S. and Italian economies, where we depend very heavily not just on the ability to manufacture things, but on the ability to add value to goods and services through our creativity, our innovation, our ability to invent, the outstanding reputation that comes with our goods and services, and we protect these things through imaginary, fictional rights called intellectual property rights. And the lessons of recent years have proven to us again and again the necessity of making sure that partners all around the world protect those rights, so that when our goods and services that depend on a value-added component go out into the global economy, they will enjoy protection, and they will be able to return revenues to their creators from markets around the world in the context of a global economy. Rewards of a well-functioning intellectual property system are, of course, potentially enormous. The value of intellectual property rights has grown tremendously in the past 40 years. In the value of intangible assets in U.S. corporations alone was about 40 years ago around 18% of the book value of the S&P 500 index. Today, intangible assets like patents, copyrights, and trademarks represent nearly 80% of the book value of the S&P 500 corporations. That's a staggering testament to the fact that more and more economic value in the global economy depends on protecting intangibles. In the United States, our Department of Commerce recently did a study on the employment value of intellectual property intensive industries. The Commerce Department found that those IPR intensive industries, the ones that depend most heavily on copyrights, trademarks, patents, accounted for about 35% of U.S. gross domestic product and more than 60% of United States merchandise exports. About 40 million U.S. jobs, or 28% of all the jobs in the United States, were found to be directly or indirectly attributable to IP-intensive industries, industries that depend heavily on the ability to protect intangible assets. Those rewards are by no means limited to just the large corporations, far from it. On the contrary, IP rights are tremendously empowering to small businesses and individual creators. In the United States, we find that the venture capital economy is often driven by an idea that exists only on paper, that exists only as a trade secret until it obtains patent protection, or for example, in the context of a new venture that's going to be embodied in something like an iPhone app that will be written, protected by copyright as software, and then protected by a variety of copyright and related mechanisms as it goes out into the digital environment as a means to monetize innovation. In these and many other contexts, strong intellectual property rights are absolutely vital for innovation, in providing opportunities for entrepreneurship, for young and old alike, and for economic growth as well as development and responding to our shared priorities around the globe. Intellectual property rights provide critical incentives to innovation that will drive technological growth, incentivize the transfer of critical goods and services, promote growth, and create jobs, particularly in developing and least developed countries that need those benefits the most. That kind of protection is really essential to facilitate access to and transfer of technologies and promote tomorrow's innovation in fields like green technology, healthcare, and many others. Without those kinds of protections, a lot of the technologies on which we rely today and will rely on in the future would not be developed. Consumers and inventors alike would be deprived of critical advances with respect to priorities like health, food security, the environment, e-commerce, and many others. One of the ways in which intellectual property rights are a key driver of private sector investment and economic growth is evident in the tax base. It's evident that pirates and counterfeiters don't pay taxes themselves. It's sometimes less evident that they also take opportunities away from those who do pay taxes. So in times like these, when governments around the world are looking to strengthen their tax bases, it's vitally important that we promote legitimate businesses and deny opportunities to those who would take opportunities away from legitimate businesses. The relationship between IPR protection, creativity, and economic growth is particularly prevalent when it comes to this issue of protecting against piracy on the internet, and that's why the draft AGCOM regulations to combat piracy on the internet are so important. And the United States wants to recognize the hard work that's gone into their development and drafting already, and the complexities involved in addressing those issues. That's certainly something that we're quite familiar with from the U.S. context, and I wanted to provide a few remarks this morning about some of the experiences we've had in the United States with our own laws in this area, including the Digital Millennium Copyright Act. The Digital Millennium Copyright Act, or DMCA, is a key piece of U.S. law addressing piracy over the Internet. There is a broad consensus around the importance of this legislation, not only in terms of its notice and takedown and safe harbor regime, but also for its role in promoting e-commerce and growing the digital economy in the United States. And let me not ask you to take my word for it, but point you to some of the comments of the technology industry in the United States about the importance of this notice and takedown and safe harbor legislation that we've had in place for some years now in the United States. So let me start with a comment from Microsoft Corporation, recently testifying before the Judiciary Committee of our House of Representatives. A representative of Microsoft said, 15 years ago, in the DMCA, Congress helped launch a new wave of online services by establishing a safe harbor that limits the uncertainty and risk faced by telecommunications companies, search engines, and other online businesses. Also recently in 2010, when our intellectual property enforcement coordinator in the United States sought views from industry on online copyright enforcement in the U.S. context, one of our prominent technology industry associations came forward and said the following. This is from the Computer and Communications Industry Association. And they said that the notice and takedown regime in the United States carefully balances the interests of copyright owners and service providers. In essence, it provides copyright owners with automatic injunctive relief, stopping infringement without stepping into court. At the same time, it shelters service providers from liability for infringing activity initiated by millions of third parties. The DMCA is not perfect. Nonetheless, the DMCA remains the appropriate framework for copyright enforcement in the digital environment, according to CCIA. Let me also share with you some of the comments we received when the United States did a notice of inquiry 2 years ago on the free flow of information in the Internet environment. I know this issue of Internet freedom and the free flow of information is a critical one in the discussions here in Italy about the enforcement of intellectual property rights on the Internet. So let me share with you the comments that were made by the U.S. company Google in the context of this notice of inquiry at the Department of Commerce on the U.S. DMCA regime. Google said that the safe harbor regime in the United States has a variety of important benefits for free expression and information flows. According to Google, that U.S. regime protects the principle that information ought to be treated as innocent until proven guilty, and ensures that intermediaries need not subject every video, blog post, tweet, or search query to pre-screening surveillance and monitoring. It prevents so-called overblocking of content by intermediaries who are fearful of the legal compliance costs that would be necessary. It fosters transparency, affording complaining parties and those complained about an opportunity to engage with each other directly. It treats fairly small enterprises and startups, which would otherwise be burdened by legal regimes that are unclear or costly. In its comments, Google says, Google submits that these balanced legal protections for Internet intermediaries are crucial in promoting free expression, innovation, and economic growth online. One need only consider the tremendous recent growth in participatory media, also known as user-generated content, online to appreciate the enabling effects of these legal regimes. Participatory media sites like YouTube, Facebook, Blogger, and Twitter have become vital forums for all manner of expression, from economic and political participation to forging new communities and interacting with family and friends. These kinds of sites simply would not exist if intermediaries faced the risk of monetary liability for every item posted by millions of users. Put in place in the late 1990s, the legal standards that govern Internet intermediaries in the U.S. have proven to be a success story for promoting innovation, creativity, and human development. The Commerce Department, other U.S. agencies, and other governments should work to demonstrate the benefits of these sorts of regimes and resist efforts by other governments to fashion differing legal regimes that would force intermediaries to clamp down on free expression. So this is in the context of, these are the comments that we received in different contexts from different perspectives in the U.S. technology industry on the importance of this notice and takedown and safe harbor regime that we've had in place for 15 years now in the United States. And it's certainly the perspective of the U.S. government that we feel like the existence of this regime in the United States has played a really critical role in making possible the growth of online services like Facebook, YouTube, and many others. And likewise, we feel that the AGCOM regulations offer a significant opportunity for economic growth here in Italy by addressing the growing problem of copyright piracy and trademark counterfeiting on the Internet. Piracy is, of course, severely damaging the legitimate market for the distribution of copyrighted works and trademark goods for both Italian and foreign artists and creators. And in this field of online piracy, it's been the unfortunate fate of the music industry to be the leading indicator of the development of both the problem and the solutions. And if you look at the trends in terms of music sales, for many, many years it's been declining. What's interesting is in some of the markets where strong legal regimes are in place for online distribution, you've started to see that trend flatten and the curve even begin to turn upwards, so that now we see growth in online sales, and for the first time in many years, growth in music sales that were declining year on year, year after year. We have not yet seen that growth penetrate into the Italian market. We would very much like to see the kind of legal regime be put in place here that would support that kind of growth going forward, so that Italy can join a number of other economies where finally the trend is turning around and sales are beginning to climb, and that we think will benefit not only the music industry but also many other content-intensive industries. So it's with that economic benefit in mind, as well as the benefits to free expression and the benefits to the cultural sector in general, that the United States encourages Italy to pass regulations that are swiftly adopted and implemented and that create an effective mechanism against piracy over the Internet and address all types of infringement that takes place online. The increased availability of broadband Internet connections around the world is, of course, generating tremendous benefits, both economic and cultural, and it's also generating new business models to provide greater access to an exchange of information. It's at the same time, as the previous remarks this morning indicated, a great vehicle for the exchange and dissemination of copyright infringing products. For example, so-called linking sites that index to infringing content hosted elsewhere are a major issue. Likewise, peer-to-peer networks are a significant concern. I'm, of course, not the first one to conclude this, even on this panel this morning. So the lesson we take from all of this is that we must do what we can in every national context around the world to ensure that we're putting the laws in place to make the Internet a platform for economic growth. To take advantage of the opportunities that it affords, countries around the world have to take steps to address the challenges of online piracy while ensuring that our shared values of free expression and privacy are preserved and respected in the process. It is just absolutely critical that governments around the world stand up for the rule of law in the online environment. You'll find very few governments around the world that take as strong a position as the U.S. government on internet freedom and the importance of free expression in the internet context. That is a core value of the United States and one that we think is very important in the online environment. I'm here to say that from the U.S. perspective, that value goes hand in hand with rule of law in the internet environment, and we're very grateful to see the government of Italy working to promote not only the free exchange of information online, but also rule of law in an internet context, which is really critical for making sure that the online environment, like the physical environment, is one in which creative people can thrive and prosper based on the ability to market their products and services. Whether the value that those creative and innovative people add is embodied in innovations found in our electronic devices or in the legitimate goods and services that you buy with those electronic devices, we have everything to gain as trading partners and in the U.S.-Italy trade relationship by creating an environment in which that kind of value can be traded and its creators deservingly rewarded through international commerce. So it's with that thought that I thank you again this morning for the opportunity to talk with you and for all of the work that AGCOM and the wider stakeholder audience have been putting in on this important issue.
We thank you, Mr. McCoy, for your interesting and wide-ranging intervention. We really appreciated it. We took good note of both the intervention of this morning. Io credo di aver terminato.
At this point, I believe I've done my duty. And it wasn't just a duty, it was a pleasure indeed. And I am very happy to hand the chair over to my friend and colleague, Mr. Maurizio Decina, who is going to moderate the first panel of this morning's session. Thank you, and Maurizio, the floor is yours.
I think we have to go down. I think. I'm not sure myself. Let me see. Yes. We vacate. Let me take my glass.
May I invite here Mr. Guerfos, Madame Jacquier, Mr. Cowie, and Mr. Vanik.
I wanted just to say hello before meeting you later today.
Thank you very much for coming. I look forward to talking to you later today.
Per amore e scienza per riguardo il
il 12:50, faccio fare prima delle domande agli inglesi e poi basta, quindi è uguale al suo ma è spostato.
È spostato?
Sì, sì.
Allora, possiamo ricominciare per favore, se vi sedete, grazie. Can you take place, please? Allora, questa mattina abbiamo ancora due sessioni.
So this morning we have two sessions. The first will involve our foreign guests, and the second will involve and feature Italian experts in the area of copyright enforcement.
The first panel today is composed by distinguished experts coming from different countries in Europe, from the UK, from France, from Spain, and from Netherlands. And they will tell us about the different regulation or regulatory models adopted in these various countries in order to protect the intellectual property of digital works when they are posted and distributed and consumed over the internet. Before giving the floor to our distinguished speakers, I would like to give a little preamble trying to stress some of the issues that I feel are very important when we are dealing with this very complex subject of the copyright protection in the digital environment, and especially in a networked environment. I do believe that the awareness of consumers when they are surfing the internet is of extreme importance with regards to three issues. Issue number one is the security, in particular the identity security in order to prevent frauds. The second issue is privacy, protection of personal data, profiling, and so on. And the third issue is protection of intellectual property. My view is that my experience in all these three areas is that consumers need to be educated in order to understand what security means for them when they're surfing the net, what privacy means when they're surfing the net, what respect of the intellectual property means when they're surfing the net. This is an extremely important point because I don't believe that protecting the intellectual property means only enforcing stopping the crimes. There's certainly a major part of it, but the ultimate goal is to arrive in an environment where consumers are aware of what they're doing. According to some inquiry that I've seen, 75% of the surfer, the cyber surfer, don't understand what copyright means. They are not aware that they are committing a crime or an administrative crime when they are downloading without paying the royalties a song or a movie. So this is a very important aspect of it. The other point is there is no doubt that talking now of copyrights as opposed to security and privacy that are rights of the citizen, here the game is on permitting innovation. We know that patenting and innovation is at the core of the growth of a country. In this country, we have launched a program of startups. The startups are normally based on an innovation, on a patent, okay, on a core patent by which they can go into the market and be successful. Protection of the intellectual property, then, is a key issue for permitting the growth of the country. There's no doubt about that. On the other hand, you know, self-regulation would be the ideal ultimate goal over the internet in order to guarantee protection of the intellectual property. Self-regulation. If all the site owners and the page owners of the webs will be auto or self-regulated, then making themselves under a specific notice or report of a possible infringement, if they do by themselves the inquiry and they do by themselves, they take down. We have an example for this now in the current YouTube. Google is exactly a self-regulation. So when Google gets a notice of an infringement, is obscuring the object, is doing a very quick investigation, and according to the investigation, the file or the specific file can be taken down by the owner of the page, the owner of the site, by himself without involving enforcement or authority intervention. So this is an ideal system, and we got to get there. To get there, it will take time, and during this time, we have to do a number of things. Certainly, education is one of the key issues that we have to pursue to get the long-term goal. Certainly, the promotion of, as we have heard by the previous speaker, the promotion of the legal use of products protected by copyright in the net, taking advantage of the network. The network is known as a market with a long tail. The network is opening and enlarging the market for the content owners. So their policy in selling products over the net, and they should change their policies in order to encourage people to have a consumption of the legal use of digital works provided over the net. So education and promotion are key issues. On the other hand, what I believe and what our chairman was trying to indicate shortly in his introduction this morning, we at AGCOM believe that we have to give priority to stopping the serious infringements into the net. The massive piracy sites, the massive piracy platforms that are doing video streaming of illegal files that do not respect the intellectual property. This must be priority number one. On the other hand, also, the tendency in our discussion insofar has shown that these are the prime target of the enforcement. Certainly, we are not going at the beginning of our exercise to shoot for the prosecution of the downloaders. That is even a very much more complex issue to take in view of this bilateral view. On one side, I want to enforce the right of the authors. On the other side, I got to enforce the right of expression of all the citizens in the net. So I got to find a real balance when touching this issue per se. The other things that we are thinking also is that an authority like AGCOM should be ready to go into the net and under a strong notice report take action, only under a notice report take action. So we are not going to make monitoring or continuous monitoring. We are going to react to a signaling that is going to the authority, and the analysis, the investigation that we are going to carry will be an investigation that will require not only human skills adapted to understand that, but also technology. So we are going to try to use the latest technology of parametric search engine in order to check, okay, the validity of the copyright by looking at fingerprints into the digital files of movies, of sounds, and also editorial type, press type of intellectual properties that we have. So, having said that, also the issue of enforcement must be carefully developed through the years. Certainly there is the block of the access to the illegal file. Blocking the access to the illegal file is also something that needs fine-tuning. Yes, fine-tuning. In order to guarantee the right of expression, we got to be very careful in shooting down one IP address with an entire site. If the entire site is piracy, that's very fine, very beautiful. But in many cases, the site may be shared by illegal files and legal files, and we got to be very careful in doing our enforcement here. The other alternative, what was signaled by Kerstin Jorna, is the block of the e-commerce, the financial transaction that goes between the site of page owners and maybe the uploaders, the massive uploaders of illegal content, and the downloaders. So the follow the money approach mentioned there is another tool that we got to explore in this difficult exercise. Having said that, I would like now to pass the words to our guest. I think our first speaker is going to be Sarah Jacquier. She's a legal director of Adopi, the French government legal initiative to curb file sharing. And Ms. Jacquier is joined Adopi in April 2010, and she had some previous experience in the legal area, especially connected with the digital world and the internet. Sarah?
Yeah, okay.
It's okay.
Well, first, it's a great honor and a great pleasure to be here, especially in such premises. Well, thank you very much for Agicom to organize this event and give me the opportunity to sit with other regulators involved in the problem of copyright protection. I was invited here several weeks ago to speak about Adopi and the French model concerning online protection. As some of you already know, I'm sure, a report commissioned by the French government was issued a few days ago. And it's on the question of the adaptation of French culture policies to the digital age. And of course, it can have an impact of Adopi. The report is made by Pierre Lescure, a former chief of the pay TV channel Canal+. And it's a huge report, like it's a 500-page report with 80 recommendations. The government, the French government, is now evaluating the recommendation in order to select those which will be implemented, and it could then submit a bill to the Parliament with the selected recommendation as necessary. Because of this current review of the government, and because I'm sure you will see that I am not Pierre Lescure, okay, I shall concentrate my speech today on the activity of Adopi since 2009, but also, of course, giving you a flavor of how Adopi's mission could be impacted by Lescure recommendation if they were implemented. So, Okay, so let's talk about, we're here today to speak about models, policies, what happens in France, what happens in other countries. Well, let's step back in 2009. France is, like other countries, are facing the situation where massive infringement acts take place on peer-to-peer networks. And it decided to act. And they decided to create an agency, a dedicated agency specialized in the problem, and to entrust this agency with the mission to implement a graduated response mechanism. The graduated response mechanism focuses on the Internet users, more precisely on the Internet access subscription. The idea is to raise, and as you, Mauricio, as you indicated, the idea is to raise awareness of the users on the need to protect copyright and the harm that can be done by piracy. Of course, the idea also is, so the purpose of the graduate response is mainly educational. It's also to substitute to replace the infringement penalties that can be very high by lower penalties. So that's the idea. So really, in 2009, the idea is to implement a graduated response mechanism that has an educational goal, and the purpose of which is to raise awareness as to the need to protect copyright, and taking into account the fact that infringement penalties are too high, they are not reasonable for end users. Why a public agency was created to do this job? Well, it has to do with the fact that copyright protection is a public interest matter in France. And protecting fundamental rights is typically an area where you can find public agency dedicated to this kind of things in France. You can also find this public agency in economical activity, like, for example, Ofcom or Agicom does in telecom business. And there was another reason why we created the public agency. And this is important to understand because, as you know, there are some graduated response which are implemented throughout the world on a voluntary basis, on voluntary scheme, which is not the case in France because a law was issued for that. Well, it is because the French Parliament had the feeling that there was a need to put an independent intermediaries between the rights holders and the ISPs. So they didn't want the rights holders to have the personal data of the subscribers, of the Internet users. So that was really the logic. Other things I would like to stress about the choice that was made in 2009 is the fact that the graduated response was not the only mission entrusted to Adopi. Okay, it's the only one people speak about, but it was not the only mission. First, Adopi inherited from the mission to regulate TPM, technical protection measures, which are, the technical measures that limit the usage that can be made of a work of authorship. Like, for example, limit the number of copies that you can make. As you know, the directive of 2001 on the harmonization of certain aspects of copyright required protection of the TPM by member states, but also that member states take appropriate measures to ensure that TPM do not deprive consumers from the benefit of certain exceptions to copyright. And France's answer to this requirement was to create a regulator to find a balance, that's what you were saying earlier, find a balance between rights holders and the public. It is worth mentioning that France went beyond the requirement of the directive because this regulator is in charge of finding a balance concerning the area of exception to copyright. But beyond that, it's supposed to ensure interoperability. That means the idea is that the consumer who purchases legally a content must be able to read the content on any kind of device he wants. That was not a requirement of the directive. So that was the first step that France, they wanted to do in order to promote a legal offer that is attractive to the consumer. That leads me to the second mission that was entrusted to Adopi. So we have the graduated response, we have the regulation of the technical measure protection, and we have the encouragement of the development of the legal offers. What does that mean? It means that Adobe has a power to grant a label to websites that have all the required authorization from rights holders and content owners, and that make the application to Adobe to have such label. Label is not mandatory, okay? You can be a website in France without having a label. But if you want to have this label and you have the authorization, then you can apply to the label to Adobe. The label has two impacts. The first thing is to get the site that has the label gains in visibility because it is referenced on the public website of Adobe. The second interest, and I'm sure you're familiar with that also because talking with my international colleague, I think we're all facing the same problem, is that very often consumers don't know what is legal and what is not. Well, with the label, they know. So that was the idea. Last, Adobe was also entrusted with a mission to observe the usages on the internet, try to understand the behaviors of the people and what's going on out there, you know. And I think that joins a general concern we have in terms of public policies, which is to adopt policies that are evidence-based. That's the purpose of this observation mission, is to produce objective data on which the regulator and the public authorities and the lawmaker can rely, but also the private stakeholders. So in 2009, you see that already in 2009, we had the conviction in France is that enforcement of IP rights cannot go without promoting legal offers and promoting awareness of the consumers. And I think that's quite close to what you said, Maurizio, earlier. Now, I would like to just focus a little on a graduated response because, after all, that is what we are famous for. As you know, the basic idea of the graduated response is to send Internet access subscribers whose Internet access is repeatedly found used for infringement purposes, warning notices to asking them to take appropriate measures to secure their Internet access, and ensuring that their Internet access is no more used for illegal purposes. There are 3 stages: one mail with a registered letter, then an information that the file can be handed over to the prosecutor, and at each stage, the Internet user has the possibility to discuss with Adobe. Actually, that's what we're here for, to discuss with people. Few things to note about the graduated response. So what do the rights holder do and what Adobe does? Well, rights holders are the ones who connect to peer-to-peer networks and observe the infringement acts and do the infringement report. Okay? We are not doing that. Then they hand over the reports, the copyright infringement report, to us. We are not doing the monitoring of the networks. Why I am telling you, I'm talking about the Internet access subscriber and not the Internet user. It's because with the graduated response mechanism, we don't want to know who, if the Internet user or in the Internet, the person we are facing is directly and personally liable for infringement acts. We don't want to go into that route. I mean, what we want to know if its Internet access was used for illegal purposes. Which are the intermediaries involved? It's ISPs because they give us the identifying data of the Internet of the people, and they send the warning notices upon our demand. Last, do we do all the job? No, we don't do all the job, because once we have the conviction that a gross negligence is happened, that we are facing to someone who is responsible for not having securing Internet access several times, then we can hand over the case to the prosecutor, who's responsible for deciding or not whether to file a criminal pursuit against this person. Adobe is no longer in the picture at the moment. Why do we have to refer to the court? Well, it's because the French Constitutional Court in 2009 decided, it's because of this famous Internet suspension access penalty. The French Constitutional Court decided that this job could not be entrusted to a public agency. It was a job for the court, for the judge. This is why we find the rights holders, the adoptee, and at the end of process, the judge. Key figures about the graduated response. Okay. So I think this slide is self-explanatory. Well, it means the efficiency of the graduated response, I think. But you can compare the total first warnings, about 1,800,000, and then 106,000 second warning notices. The number of deliberation refers to the time where the body in charge of the graduated response inside adoptee decided or not to hand over the case to the prosecutor. Okay, so if we're running out of time, so please go ahead. So now, what can happen with the Lescure report on the graduated response? Because I know that there have been lots of articles, newspapers on that. Well, first, Lescure report recounts some efficiency to the graduated response. He welcomed the fact that the graduated response was implemented by adoptee as an essentially educational scheme. Okay, so we took the sensible approach. But he recommends to keep a graduated response mechanism, but renovate it. This renovation, in his mind, would imply abrogation of the suspension of internet access penalty, keep the procedure purely administrative, and that would be possible because we wouldn't have any more the suspension of the internet access. Okay, this refers to what I've just said, and lower the amount of the penalty that could be ordered. Basically, we are talking now of a lump sum of 60 euros instead of a maximum penalty, which was of 1,500 euros. But above all, and as you were saying, the idea now is to complement this approach and to tackle the case of the worst violators. That means the website that organize large-scale copyright infringement for commercial gain. This behavior has developed, and in France also, we are completely aware that it is a priority to tackle this kind of comportments. There's a large consensus. The adoptee made so basically what we can say based on the Lescure report, which is in line to a previous report that was made by the president of the right protection of adoptee, is that, well, we all agree on the objective, okay? We need to tackle the worst violators. But first, the situation is difficult because internet is global and you have the safe harbor status of the hosting providers. And no site is 100% illegal or illegal. Okay, so what? There is no silver bullet solution. We need new, coherent, complementary, and proportionate measures. So criminal action should be taken against the person directly liable for infringement, but this is not enough, and we need an intervention from intermediaries. Different types of intermediaries. Technical intermediaries, we already know based on the e-commerce directive that we can ask them to take measures to terminate or prevent illegal acts, regardless of the question of their liability. That's not an issue. And then for the other intermediaries, the one that make the illegal activities profitable, I'm thinking about payment processors and advertising agencies. As you mentioned earlier, there is also the follow the money approach that was developed by the Obama's administration and is now being discussed all over the world. So in the Lescure report, what is recommended is a co-regulation with the intervention of a French public authority. Again, French public authority. We need that in France to make sure that things happen smoothly. This co-regulation will require promotion of codes of conduct for intermediaries, search engines, payment intermediaries, and so on. And the authority could also establish repeated copyright violation by sites, which can serve as a basis for establishing a list of websites that could be communicated to intermediaries bound by code of conduct. That is, we have this authority. They would establish that on certain sites there are repeated violation of copyright. A list would be made. This list would be handed over to intermediaries bound by the code of conduct, and an action would be expected from them. And of course, if this co-regulation is not enough, then the authority could go to see the judge and obtain orders with the same objective. Very quick on that slide. So it's the, that's all. We talked about the graduated response, how the protection of right aspects. So now we have the other missions that I mentioned earlier of Adobe. Very quickly, you can see that the label has been granted to 60 sites. We are very happy because it covers all cultural fields, music, audiovisual, different websites, and also because there are different business models involved, like crowdfunding, and we think it's good to promote this kind of model, crowdfunding. Also, I would like to talk just very briefly about the Department of Research and Development. We have a specific department dedicated to these questions. They do quality study to better understand the usages, but also they do direct measurements on the network and the services. For example, they studied the population on YouTube, and they saw that music video were the most popular content. They study different things, and I have to say that what is very important for this department at Adobe is that it is really the purpose really to conduct independent studies and not to be afraid of the results. I mean, for example, in one study made by Adobe, it was clear that people who download illegally are also people who consume legally, and Adobe published this report. Okay. Regulation of technical protection measures. I'm just so that's you stay, please. Yeah. No. Yeah. Okay. So that's the last bullet point. It's just this mission I presented it earlier. It hasn't been enough successful. This is due to different factors. I think it's because the provisions are extremely complex. And the Adobe cannot act on its own initiative. It needs to be faced. I mean, some people need to go and see Adobe for arbitration, and this is why the activity has been limited so far. So that's the end. So the conclusion in the Lesker report, is that not enough has been made as far as promoting legal offers is concerned. And that the situation must be, the current powers must be reinforced. So the efforts to promote legal offers must be sustained, but this promotion must be part of a more global strategy aimed at promoting cultural diversity. Hence, the offer must be legal, that's true, but also attractive, diverse, reflecting French objective of cultural diversity and different business models. The proposed measures, some of them could be assumed by the audiovisual regulator, CSA. They have different objectives. Facilitate access, for example, by relaxing the rules governing video content distribution windows, and ensuring a better redistribution of the value generated by online distribution between content owners on the one hand and and internet and equipment giants involved in the distribution. For instance, by creating a tax to be levied on connected equipment. I'm mentioning this example because it was much debated. Okay, so we'll see what happens next in the next month, and I thank you for your attention.
Thank you very much, Sarah, for your very interesting talk. I think we will have some time, I think, at the end of the session to have some questions. I was very much interested in your speech about the promotion of the legal offer. Very interesting. I think in the legal offer, what I appreciate is this interoperability aspect that you mentioned. This is part of the right of the users. We have not to forget what are the rights of the citizens, of the user in the net. For instance, in the real world, I can buy a movie and I can lend the movie to a friend. I can resell of a used movie to another friend, I can make a gift to another friend. So things like this must be respected when enforcing the copyright in the net. So then let's go now to our second speaker in our session, Campbell Cowie. He is a Director of Internet Policy in the Ofcom. Campbell joined Ofcom in 2008 as Policy Director in the Strategy and Market Development. He's an economist, and he is going to tell us about the experience in the UK and the copyright, the digital copyright protection. Campbell?
Thank you very much. Good morning. My name is Campbell Cowie, and I'm the Director of Internet Policy at the UK's Office of Communications. Ofcom, as it's more commonly known, is the UK's independent regulator for television, radio, telecommunications and postal sectors. First of all, I'd like to express my thanks to our kind hosts for inviting me to discuss how online copyright infringement is addressed in the UK. I'll begin by explaining the institutional structure of responsibilities in the UK and then focus the remainder of my talk on Ofcom's activities and experience in this area. The responsibility overall for intellectual property policy lies with the Intellectual Property Office, an agency within the Department for Business. The IPO is responsible for the development of policy and legislation, but it has no enforcement powers. A second government department, the Department for Culture, Media and Sport, is Ofcom's sponsoring department, and for reasons I won't go into here, has the ministerial responsibility for the Digital Economy Act 2010, also known as the DEA. More on that later. Enforcement of copyright in the UK is a matter left to the courts, primarily using the Copyright Design and Patents Act, or the CDPA. Under this Act, copyright owners can seek injunctions requiring intermediaries such as internet service providers to block access to specified sites that the court has found to be infringing, and they can pursue those individuals who unlawfully share content and seek civil or indeed criminal penalties. Copyright owners were initially wary of seeking blocking injunctions, fearful of unhelpful precedents being established, the costs involved in taking such actions, the length of time such court hearings take, as well as the negative public reaction to such moves. However, there have now been a number of blocking orders issued over the last 18 months, including 3 in the past week, and I expect another 5 within the next week to 10 days to be issued. Thank you. The time taken by the courts has dropped from around 12 months 2 years ago to now less than 2 months, and it's getting faster with each case. We understand that the costs to copyright owners are now also falling dramatically. Copyright owners also report that the ISPs are now more cooperative over implementing the orders, and the broader public reaction has not been as negative as had been feared. They're a useful and valuable measure for tackling major hosting providers and indexing sites, but less useful for temporary sites such as those showing live football matches using streaming services. Overall, it's not yet clear what the impact on infringement levels has been, with some arguing that committed infringers simply circumvent the blocks or switch to alternative sites. Further independent research on actual impact of the different measures, I think, is required. Rather than using the CDPA to pursue individuals who share content, many copyright owners have made use of the Criminal Justice Act in the UK, in particular its fraud provisions, to secure criminal convictions and custodial sentences. This approach is viewed by the copyright owners as a much stronger deterrent than the civil penalties under the CDPA. Now for the Digital Economy Act. The purpose of the DEA is to deliver a scheme whereby the major ISPs and copyright owners cooperate to notify subscribers of alleged infringement taking place on their accounts. Those subscribers who receive multiple notices may be taken to court under the CDPA by the copyright owners. It is Ofcom's responsibility to draft a code to oversee this framework, to establish an independent appeals body, and to provide regular update reports on progress to the government. That's the next slide. The Act also contains provisions for a second stage involving technical measures such as bandwidth throttling and temporary account suspension. This stage requires yet more legislation and can only be implemented following 2 separate reports from Ofcom, including one on the potential efficacy of such measures. It would also require a new code to be drafted by Ofcom and the establishment of a judicial process for hearing appeals. Based on our experience, about which you will hear more, that could take a number of years. The Act also includes provisions for a new approach to the issuing of blocking injunctions against infringing sites. Ofcom was asked by the government to review those provisions in the Act, and following our advice that those sections of the Act were unlikely to deliver against their objectives, the government has said that it will repeal those provisions. I've included the URL for the report, and it's available on our website. The next slide, thank you. You may think that an Act passed in 2010 would have been implemented by now, and that I'd be able to talk you through our success. Unfortunately, a number of delays mean that this is not the case. First, there was an unsuccessful legal challenge made against the government by 2 internet service providers. This delayed the implementation by around 18 months. That, however, did not mark the end of the delays. The Act is incredibly complex, as it requires 2 further pieces of legislation to be passed by Parliament before notices can be sent. The second element is Ofcom's drafted code. The first element, the legislation that establishes how notification scheme envisaged in the DEA is to be funded between copyright owners, ISPs and subscribers, was laid by Government and Parliament in June of last year. Parliament queried whether this legislation complied with Treasury rules for public bodies, such as Ofcom. DCMS, our sponsoring department, postponed the parliamentary debate on the legislation to allow time for an internal government examination of the scheme. The nature of the issues under consideration is fairly technical, and we are still awaiting resolution of those discussions. And all of that in turn means that nobody, least of all me, is able to answer one of the key questions of the operation of the code. When will the first letters to subscribers hit the doormats? What we do know is this will not be before the end of 2015. I can, however, set out for you briefly what we will need to do to get from here to there. When parliamentary approval is granted, Ofcom will finalise and publish its draft code. Brussels then needs to give its approval, a process that typically takes 3 months. Assuming that goes smoothly, we will then appoint an independent body to hear subscriber appeals against allegations made under the code. Only then can we publish our final code, which in turn also needs parliamentary approval. I know these rules are very complex, but you know how we British love our rules. The next stage is then for us to see how much we think copyright owners should be charged for each report of an alleged copyright infringement they wish to have processed by an ISP. And then to secure agreement on a legally binding number of infringement reports with rights holders. Only then can we require the ISPs to build the systems to automate infringement report processing and the sending of subscriber notifications. Following that, and provided ISPs are paid and that we are satisfied that the evidence gathering procedures are sound, copyright owners can begin sending infringement reports. That is the point, probably around 12 months after parliamentary approval of our code, where we expect the first subscriber notification letters to arrive on doorsteps. At this point, some of you may be wondering if the numerous hoops still yet to be jumped through are actually worth it. One way to answer that is to look at the current situation in the UK for sending letters alleging infringement to subscribers and for pursuing court action for alleged infringement using the CDPA. First, copyright owners find it difficult to target legal actions. A content owner observing multiple infringements of their copyright cannot easily tell whether these are from a single dedicated infringer or multiple instances of, for example, children using a grandparent's internet connection to download the odd track. To determine this, the copyright owner would typically need to secure a court order for each infringement, requiring the ISP to disclose the identity of its subscriber. Second, consumers are not always clear on who is using their connection and for what purpose, or how to go about securing their connection. Third, there's little transparency for consumers on how evidence of infringement is gathered by content owners, and no review mechanism for the allegations received, apart from through the courts. And fourth, abuse of the current system has led to alarming and threatening communications such as those sent by a small number of law firms, which has been heavily criticised by both consumer groups and indeed by the UK courts. The Initial Obligations Code, the Ofcom Code, has the potential to make a difference to all of these issues. It enables copyright owners to target their legal action against those linked with multiple infringements rather than occasional infringers. It requires a robust and transparent standard of evidence to support allegations of infringement. It offers a clear means of educating consumers about copyright with notifications that help them find lawful sources of content. It allows time for consumers to change their behaviour or take steps to secure their account before they receive further notifications. And it provides a mechanism for subscribers to appeal against allegations of infringement. I think these are all clear improvements on the current situation. However, there remain a number of concerns, for instance, in relation to the treatment of public Wi-Fi and to public bodies such as universities and libraries. We sought to clarify their status under the code, that we propose they have no obligations, and we will continue to work with those stakeholders so as to avoid unnecessary steps being taken by such bodies such as closing down their Wi-Fi and internet services. So that covers the main elements of the DEA implementation timetable and the key issues that we face. Next slide. I'd like to finish by giving some context for the broader discussion on measures to tackle copyright infringement. One of Ofcom's often overlooked new duties under the Digital Economy Act is the duty to report to the Secretary of State on online copyright infringement and on progress reducing it. This duty kicks in as soon as the first letters are sent under the scheme. However, the government has provided funding for Ofcom to conduct research ahead of the formal duty. We've published 2 waves of consumer research so far, as well as a deep dive analysis of the data that we've generated. The purpose of the deep dive was to examine in more detail the complex relationship between general consumption, infringement attitudes and spend across 6 key content types. Next slide. I'd like to draw out 3 key points from the research. By way of background to the first point, we've seen online content services developing strongly in the UK over the past few years. The number of services has grown, and they offer ever greater repertoire with constant innovation in business models and user interfaces. And some content sectors are trying hard to educate the public and to change attitudes towards copyright. So in this context, it's interesting that 2 related issues come out loud and clear from the research. Consumers remain confused about whether the content they are accessing is actually licensed. Nearly half of internet users say that they are not confident in determining what is legal and what is not when downloading, streaming or sharing content online. Next slide. Furthermore, infringers still cite price, availability of content and greater clarity over what is legal and what is not as factors which would be most likely to make them stop infringing. By way of contrast, only 16% agreed that receiving a warning letter from their ISP would deter them. Of course, claimed behaviours in relation to future actions should generally be treated with caution, and we need to do more work to understand this finding. But it does strongly suggest that a notification scheme should ideally be complemented by other measures such as fair blocking, better lawful services, actions such as follow the money, improved education, more credible enforcement against individual infringers. I'm aware of the view that says the focus should only be on commercially infringing sites, but our consumer research suggests strongly that a mix of measures must include those targeted at reducing demand for infringing content. Another key point is that unlawful consumption of copyright material remains a relatively niche activity. It involves a fairly small number of people, but accounts for quite a lot of all material consumed online. 1.6% of the internet user population aged 12 and above in the UK were responsible for 79% of infringed content. 3.2% of internet users aged 12 and above in the UK were responsible for 88% of infringement. This suggests that any mass market notification scheme will need to be complemented by other measures targeted at this hard core of serious infringers. This may mean that the targeted legal action of the type envisaged by the DEA is actually valuable. The final point I'd like to draw out from the research relates to spend. our survey indicates that for some content types, those who consume both lawfully and unlawfully claim to spend the most on content. The top 20% of infringers, for example, also spent significantly more across all content types on average than either the bottom 80% of infringers or those who claim to not infringe at all. The figures I have are in pounds, so I'll make a rough in my head calculation of what it is in euros. The top 20% claim to spend approximately 200 euros over the 6-month period. The bottom 80% of infringers claim to spend about 120 euros over the same period, and the non-infringers at all spend only 80 euros over this period. That gives you some idea, I think, of the complexity of the problem that the copyright owners face. There are a number of possible reasons for this, but a couple of related stats from the research may offer some insight. A quarter of infringers gave us a reason for infringing that allows them to try before they buy, and 40% of infringers said that they had previously accessed for free content that they then went on to pay for. The final slide, please. The research is available on our website, and I included the rather wrong URL there. And it contains a truly huge amount of data. So far, we've surveyed approximately 10,000 individuals over the 2 waves. There's a further wave of 5,000 will be published in the next week, and then we have 1 more wave to go. So it'll be a total of 20,000 individual internet users that we will have surveyed as part of this work. And we've published all of the data sets, so you don't have to take our word for it. You can examine the raw data yourselves. And I urge anyone interested to take a look. Our intention has not been to draw policy conclusions from the data, and instead we're seeking to just simply paint a picture of how users of digital content and of their behaviours. However, we hope that the data on the behavioural drivers of those who infringe copyright will help policymakers around the world who are developing new policies to address online copyright infringement. Thank you.
I think so we will have some time at the end of this international panel to have some questions from the floor to our speakers. So thank you very much, Campo. Let's go now to the next speaker in our session. He is Carlos Guevos Marillo, Deputy Director General of Intellectual Property in the Ministry of Education, Culture and Sport in Spain. Carlos is a graduate in law. He has been involved in coordination of security forces and immigration matters and many other issues, and he specializes in immigration law and intellectual property law. Carlos?
Grazie tante Maurizio. Signori, Ministro, autorità.
Ladies and gentlemen, ministers, colleagues, first of all, I'd like to extend a very warm greeting to the Italian people and their representatives and the Italian government. Congratulations to AGCOM for having organized this initiative, and many thanks for the invitation. I'll be speaking in English because I don't feel very safe in Italian yet. So next time I'll venture out into Italian.
Today we're talking about different regulatory models for security of copyright in Internet. Which is the current situation? Well, when we speak about copyright, we are dealing about a private interest, but I would say it's not only a private interest, because copyright is absolutely connected with the ensuring of cultural creation, ensuring and protecting cultural diversity, and some figures about wealthiness and employment have been put today. And I can tell you that in the concrete case of Spain, copyright is crucial for our economy because it makes almost 4% of our GDP, and it means more than 500,000 employments in Spain. Technologies are a fabulous platform to make legal offer. It's a fabulous platform for authors, for creators, but misuse of new technologies is also provoking worldwide losses in economic and employment terms. So if we let things just go on, we will have serious difficulties to achieve a minimum safety standards in state legislation in this issue. But we have seen that solutions will not go through with measures on a single approach. We need a multidisciplinary approach or measures adopted unilaterally. Internet is something global, and we need to work together, all governments or all countries, to fight the infringements of copyrights in Internet. Please. I would like to put some ideas about how we regulate the Spanish domain extension, which is that you see, it's .es. Red.es is a public agency, is the public entity of the Ministry of Industry in charge of consolidating the development of the information society in Spain. The domains .es are growing more or less 10% each year, and at the moment they reach a total of 1,600,000 of domains. Domains.es provide a difference for us because they reinforce the identity and proximity of projects, and they favor the identification with Spain, with Spanish language, and with culture in Spanish. I must say that Spanish is the third language more used in Internet, just after Chinese Mandarin and English. Yes. What's the objective we try to achieve with the domain.es? We try that anything which is illegal in the physical world must be illegal in Internet and must have the same consequences, not more, not less. The same consequences as if you infringe the law in the physical world. So this public agency has some rules to cancel the domains. The domains must be legal, the content must be legal, and in other case it must not exist in the cyber world. A domain.es can be cancelled by this public company, Red.es, or on request by InterestPad in the following cases. First, when domain names are requested by persons or business with no interest or no relation with Spain. We want to make a strong connection between this domain and our cultural world and our enterprises. Secondly, when the beneficiaries of domain names composed exclusively of proper names and surnames are not directly related to these names and surnames. For instance, if I try to register a domain called sarahjacquier.es and my colleague Madame Sarah Jacquier complains to Red.es to cancel the domain, it will be cancelled in more or less 10 days. After telling me what I think, what I can defend myself, of course, but it will be cancelled in 10 days as maximum. Place, and you can see I underline this case. A domain.es is cancelled when identification data stating in the register of Red.es are false or incorrect. This is crucial because if we want to implement a notice and take down procedure about cultural contents, illegal cultural contents, we have to know where or who we have to notice. So identification data are crucial. And finally, the domain can be cancelled when it violates the rules and technical conditions established by the authority of Red.es. Please. Well, okay, thank you. I have said this is a multidisciplinary issue. with many things that have to be taken into account. And so our government in 2009 set up an interministerial commission to get advice about what to do concerning copyright infringement. There were experts of 8 ministers working in this commission, and the recommendations included next. First, to set up an administrative, quick and effective procedure to restore legality, developing Article 11 of our e-commerce law, which is this LSSI, not affecting Internet end users and including mandatory judicial intervention. The result of this recommendation is what we know as leysin. It's the law which is in force at the moment, and I will try to explain with a little more detail next. The second recommendation was to analyze civil judicial procedure, which is the natural place where a private interest must be defended, excluding at that moment changes in the criminal procedure. That was in that first moment. I must say that 4 years after these recommendations, our Ministry of Justice is already working in the necessary changes in the penal law to adapt it. The third recommendation was to promote legal digital offer. Next, they recommended us to create a legal content official mark or seal. It's something very similar to what the French representative has exposed. We have been working on this seal with the same objectives as in France in these 4 years, and at the moment there are over 60 business oriented to Spanish-speaking consumers which have joined this seal. The next recommendation is to carry out awareness and education actions, and finally to establish a flexible mechanism for solving intellectual property rights conflicts about Internet content, I mean mediation. Please, next slide. Well, this is the base for our CINDE Commission, our Intellectual Property Commission. It's the Article 11 in Act 34 of 2002, our e-commerce law, which is basically the transposition of the e-commerce directive. And its Article 11 deals with this cooperation duty of the Internet services providers. This cooperation is the base of our notice and takedown procedure. Please. I have already mentioned a European directive, and it's essential because we have to take into account absolutely the European regulation. Article 118 of the Treaty of Lisbon asks for a uniform protection of intellectual property rights in the European Union. And concerning the protection of copyright in the Internet, the telecom package adopted in 2009 requires member states of the European Union, if they give powers to an organ for protecting intellectual property rights in the Internet, it establishes mainly 2 requirements, 2 red lines. First, respect the principle of contradiction. If I am infringing copyright in the Internet, I must be able to defend myself when an authority notices me for taking down. And secondly, respect the principle of judicial review. Any decision about this must be subject to the possibility that the people affected can go to the judge and can defend themselves in the judge and ask for a review of the decision. Please, next slide. So, within this framework, the Spanish Parliament approved the Sustainable Economy Law in March of 2011. This has been in the press popularly known as leysin. It makes basically 2 things. It creates an administrative body, the Section 2 of the Intellectual Property Commission, and it establishes a mixed procedure, an administrative judicial procedure of restoration of legality, focused on websites that infringe IP rights. Please, next. Which are the characters of this mixed procedure? You can read them in this slide. At first, this procedure is focused on websites that violate IP rights involving profit-making or real or potential damage. We must check that one of these requirements is fulfilled: profit-making or real or potential damage. The procedure is set up only on request from interested person, from the right holder or his or her representative. We have an identification of the web responsible only after judicial approval and hearing to the public prosecutor. Here you can see one of the red lines of the telecom package. It is a contradictory procedure. There is a hearing step, and in this step, the website that hosts the illegal content can, just at this notice, take down the content. And then the procedure, in this case, is filed, because it has got its aim. The administrative decision cannot be implemented until authorization by the Central Court for Administrative Issues. And within 4 days, the judge, after hearing the public prosecutor, the administration and the stakeholder, authorizes or not the implementation of the administrative decision. This implementation by the ISP consists of removal of the content or, in severe cases, the interruption of the website. And finally, the second red line of the telecom package. There is always a possibility of administrative appeal to the Tribunal for Administrative Issues at National High Court. Please, next. What is the Section 2 of the Intellectual Property Commission? This section is chaired by the Secretary of State for Culture, or person he delegates, and we have members of 4 ministries because we try to achieve this multidisciplinary approach. The Ministry of Culture, Industry, Presidency, and Economy. The Secretariat of the section is a public officer from the Ministry of Culture, and the requirements for the procedures for the work of the section are these: the evidence of a violation of IP rights, this I have mentioned, the profit-making or the real or potential damage, and finally, the request from interested person. Next one. There are some situations unaffected by the actions of Section 2 that cannot be affected by our actions. The situation of Internet end users, the web pages that use licensed content or which are covered under limits of intellectual property rights, and the content covered by freedom of expression and information. Which are the results of the work of the Section 2 of the Intellectual Property Commission? Well, the section began to work in March of last year, in March of 2012. And until now, it has resolved 291 of the 375 applications that have been submitted. And it has achieved the following results in 53 cases. In 24 cases, most of them are .com's domains, they have been filed after the voluntary taken down of the content by cyberlockers, by hosting websites. And furthermore, in 22 cases, linking websites not notified as third-party intermediaries in the procedures have also taken down the procedure. And finally, 3.s domains have been cancelled in this delay of 10 days I mentioned. I want to show you 2 concrete examples of what happens when the Section 2 acts on a website. Well, you know there is a war of figures, a war of numbers about what happens in the websites. We use this independent website, which is Alexa. We use this to evaluate the number of visits, and it's a totally objective data. It's totally independent, of course, from us, and it's what we use to measure what happens. Well, here you can see what happened in a real case of a linking website that stopped its activity after notification from the IPC. It's very easy to see which was the moment they received the notification. Why? Because they lose content, they are less attractive for consumers. Next one, please. And a second example, this is what happened also in a real case, what happened with the audience in a linking website that took down the links after a notification. It was not a stop of the activity, but just a taken down of the content. And you can see there is a before and after of the notification of the Commission. What we have learned in this something else than 1 year, we have seen we have a global pioneer procedure, and we have to be very prudent implementing it. We need the collaboration of IP right holders. It is essential. They must use civil tools. They must be supportive of the work of the Section 2. And we think they must complete with these actions with legal offer. Because just a tool is not enough. We need several tools tackling all problems in this issue. We have learned that the results of this first year are positive, and especially in relation to services operating from Spain. And finally, we have learned that it is absolutely crucial, and I take advantage of being in this international score now to say that it is crucial to get the collaboration of third countries from which cyberlockers and identity concealment services are operating. Please, next. I wanted to announce you that from these lessons we have learned in this year and something, we have proposed some small changes in the law to make it more effective, and the draft law amending the LES has been approved by our Council of Ministers last March 22. We expect it to be sent to Parliament next autumn, and hopefully it will be passed before Christmas. We are trying to amend the regulation of Section 2, persecuting cyberlockers but also linked sites directly. Going over the scheme work by work we have now, we want the possibility of removing all the works of the same IPR holder. We are going to propose fines up to 300,000 euros. We want the collaboration of payment intermediaries and publicity agencies. We are going to establish an electronic edicts board in the website of the Ministry to facilitate notification worldwide. We are also amending the Civil Procedure Act, facilitating access to the civil courts and permitting the identification of the copyright infringer. If we have the chance to meet in the future, I will tell you what happened with this reform and the results of it. Thank you very much. Grazie tante.
Grazie, Carlos. Grazie, and thank you very much, especially because you were perfect on time with your speech. So now I think I will give the floor to our last speaker of the session, and then I will open quickly for some questions from the floor to all four speakers. Professor Nico van Eyck is the director of the Institute of Information Law in the Faculty of Law at the University of Amsterdam. He's professor of media and telecommunication law. This is what he teaches. He's also has several charges within the Netherlands. In particular, he's chairman of the Dutch Federation for Media and Communication Law. Nico, please.
Thank you. What I will try to do is run through 4 topics, which are on slide 2, where the first 3 are directly linked to personal experiences with research and with policy development in my own country, the Netherlands. When the Dutch in 2006-2007 decided that they needed a revised copyright policy, one of the first things that they found out was that they didn't have any independent data. All the research in those days was research which was primarily provided for by the industry. So, and also we are talking about, let's say, the first years where this really aggressive debate started about who is right and who is wrong. So in order to pacify the debate to some extent, lucky me, some research institutes were asked to do some research, and the outcome was a report in 2008. That's slide 4. Where we looked into not only, let's say, the legal aspects, but also into the economic and social, cultural aspects of what was called file sharing. There were also other topics on the table, but this research was mainly focusing on that aspect. And the interesting thing was that where normally you only get a report commissioned by one ministry, we had 3 ministries commissioning the report, and it was interesting to see as researchers also how these ministries started to interact on this topic. Because before, when we met with our with the 3 ministries, we were talking to people that had never met each other. At least some of them had never met each other, which is quite interesting to observe. So what we were confronted with is, of course, next slide, is this traditional picture of those days. It's terrible in the music industry, sales go down dramatically, and it's all because we have Napster. The question is, for some, whether this development was already starting before, let's say, file sharing became an issue, but let's not go into that debate. It's more interesting to see, next picture, that it's not only about music. If you take into account other sectors of the entertainment industry, you see different developments. Particularly the game industry was growing and growing and growing. So the question is, and this is of course for economists a very tempting question, what's the market that we are talking about? Is there substitution amongst these goods, or is there maybe even substitution between consuming music and going to a bar? It's very important, because if the market is changing and the market definition is changing, then also the outcome of whatever analysis might be much more different. To be very blunt, at the end, very often money is not lost in the economy, but money is reallocated in the economy. And if you come to the latter conclusion, then of course that's a more different conclusion than saying money is disappearing out of the economy. Next slide. So we did a customer survey. It turned out that 44% of the Dutch population was involved in file sharing. Consumers were clearly not aware of the legal context. How could they? I mean, we are professional lawyers trained to understand the law, and even we have problems understanding the law, so how can you expect an average citizen to understand the law? The same was the case with the technology being used for downloading, and file sharers turned out to be the largest customers of the entertainment industry. And there was also a question asked, what would happen if you're not allowed to download anymore? Would you buy more products? And a large part of the respondents said, well, no, then we will not buy anything. Next slide. There were also questions asked about what is the reasonable price, and actually what you see is that consumers are clearly willing to pay a price which is still rather significant for the various products. Next slide. So when we had to, let's say, make a kind of summary about what are, in this case, positive and negative effects of file sharing, we came to the conclusion that positive effects are this famous sampling effect. You are able to experience all these different goods and then make a choice. We also saw that it enhanced secondary markets like merchandising, and what was also interesting was to see that there was a big tension between the demand and the offer. Are the right products being offered to the consumers at the right price? At the end, for example, for the audio industry, in this particular case of the Dutch market, we actually concluded that there was a net welfare effect which was positive, but nevertheless negative for the industry as itself. Why still positive? Because, for example, people who can't afford content are then still able to have access to the content, and that is part of the net welfare effect that needs to be taken into account. And this was also what the government asked. Do not focus on the industry as such, but look at the broader picture. So when it came to drawing conclusions, we said, well, file sharing is there to stay, it's not going to disappear, people are willing to pay. There are no clear indications that there is less creativity in society. Actually, the opposite seems to be happening. And it's incredibly important to develop new business models. Because, again, it was quite clear from the research that there was a tension between products being available in the market and products wanted by the end users. We also looked into, next slide, that's 11, enforcement. We actually came to the conclusion that there were already an enormous amount of enforcement mechanisms put into place, and they were hardly used. And it was not because they were difficult to use, they were just not being used. Some researchers claim that that had to do with the fact that already several times also at this table the conclusion was drawn that your enemies are also your biggest friends, but it remained a little bit unclear. And we also saw that the application of criminal law was more a last resort concept. This is typical also for the Dutch society, not to go into penal law, in particular not when it comes to economic issues. And the next slide is actually the most disappointing slide for me, and I was actually responsible for it, because as a lawyer you normally always ask for legal action or for legal reform, and I actually could only conclude that there was no clear indication that whatever legal solution, change in the regulation would really help solving this mainly economic problem. At least that's what the economists were able to convince me of. Nevertheless, also one of the recommendations we made was be sure that people are really more conscientious about copyright and about file sharing, because in the survey there was a quite substantial group, I think it was about 30%, who thought that all downloading was illegal, including after you bought things on iTunes. So maybe the industry did an incredible great job by making people aware of that downloading is illegal, but they also created a kind of total misunderstanding. At least there was a substantial group that really thought everything is something illegal. We ended up with some recommendations, so we said let's have no regulatory change, avoid symbolic regulation. This is typical, whenever you propose a legal change or when there is a new law put forward to Parliament, it needs to pass a kind of stress test where it is checked whether it will work or whether it will not work. This is a little bit different from the tradition in some other countries. No legal action against end users, and only enforcement on large-scale and commercial activities. In those days, this was a shocking report. The first thing that happened after we published the report was an outcry by the industry, and the industry ordered a counter-report and unfortunately had to come to the conclusion that we were not wrong. And it's interesting to hear that what I'm now telling you in the Dutch context is history, but it seems for some conclusions that are today conclusions. Well, we have also been looking back into the future. If you want to keep that paradigm, this is slide 14 that I'm now, yes. We were able to repeat the study last year, and there were some very interesting outcomes. For example, downloading from illegal sources had gone down in the music sector. It had gone up a little bit in the film sector. In the first survey we didn't include series, and it's unclear whether this change from 10 to 80% is due to that, or maybe the audiovisual sector has not yet been able to really go into new business models, as was the case, as has been the case with the music sector. So interesting to observe, there's a trend that illegal downloading goes down and it's not going up. Again, we're not sure whether this is sustainable, but again, this is the difference between 2008 and 2012, so that's a substantial period of time. Next sheet. It was also very, very interesting to observe that when it comes to where do you get your music from, where do you get your audiovisual services from, that still the purchase of physical products was the largest part of the market. The second largest part of the market is legal content. Legal in two senses. Legal in the sense of free. Just think about radio on the internet or YouTube. And then there were the paid for aspects like iTunes, like Spotify. And illegal sources came in third. So there's often the misunderstanding like we're all criminals, everybody's downloading, it's all illegal. It's not. The facts seem to be going in a different direction. It's not the first way to get access to content. So here again, next slide, we came actually to more or less the same conclusions as we did with the first research. Downloaders are also buyers, willingness to pay, and this new thing that we saw that particularly in music and audiovisual markets, that illegal sources are not the dominant form. Another project that we worked on was about internet service providers. And this was not a quantitative research, this was a qualitative research. It was done in 2010, and we spoke in 4 countries, Germany, Netherlands, UK, and France, with legislators, with enforcement agencies. And it was interesting to observe that all these interviews were done on a confidential basis, at least nobody was quoted. It was very interesting to see that already then a lot of the interviewed organizations, and we are not talking about just internet access provider organizations or organizations like Quadrature du Net. No, we're talking about police agencies, government agencies, and already they were saying, well, we have a problem with 2-3 strikes approaches because we think there is a limited social acceptance. We also have limited resources to do something like 2-3 strike enforcement. And actually one police commissioner said to me, do you really think we don't have better things to do? Plus, an interesting observation was also if you would criminalize downloading, there might be a substantial risk of downloading going underground, making it even more difficult to enforce. Proportionality was mentioned, and one other interesting observation was that it actually didn't matter whether downloading was illegal or not illegal when you looked at how people were thinking about the phenomenon, and also enforcement figures were not really different, infringement figures were not really different. So also the question came up whether enforcement effects were mere temporarily and not really structural. That's still an open question. But let me give you an interesting example of something what happened quite recently. This is slide 19. The judge in the Netherlands ordered 2 large providers of internet access, they are mentioned as Ziggo and Access for All, to block the Pirate Bay. So research was done, what's the effect of this blocking order on consumption? And at the same time, also internet providers that were not yet under that order to block were approached to participate in the research. And the interesting thing is that blocking the Pirate Bay seems not to be extremely effective because already 3/4 of the users just don't use the Pirate Bay. Some will stop, some will maybe use it less, but if you finally look at how many of the end users of an individual internet access provider are using the Pirate Bay, it's only a relatively small percentage. Plus, that's another survey which I have not put into a picture. Another interesting thing is to see that that circumvention is so incredibly easy that blocking a website doesn't really help. You need to take other enforcement measures. This brings me back to the original reason why we did the research. I'm at slide 21. The Dutch system was basically, if you really simplify it, uploading is forbidden, downloading is allowed, and it doesn't matter whether it's from an illegal or legal source. And that's then compensated by a levy system, as many other countries have into place. This is where we started in 2008, and by the end of last year, and even some things are still under development, we were able to come up, at least there is a kind of new government policy, slide 22, which has the following elements in it. Promotion and protection of new business models, that's very much emphasized. Enforcement only through civil law, and mainly aiming at websites and services. No 2-3 strike model, so no end user enforcement, also because of the idea that there should be an open internet, and subscriber data are only accessible in exceptional cases, so not in when it comes to small-scale infringement, but to large-scale infringement. This is also partly due to the intervention of Parliament, where Parliament said we don't want any download restrictions or limitations on private copying, and there is still a motion pending in Parliament about the question, should we put enforcement tasks on internet service providers, or is that not the real right way to approach the issue? My final part, and this is a little bit looking in the future, but not entirely. I think we are now going towards a kind of third phase in how we are looking at enforcement and copyright protection, and maybe even copyright in general. I think an important demarcation point was the famous Article 13A of the Framework Directive. This is the only article that I'm going to mention in my presentation, by the way. Article 13A of the Framework Directive, part of the telco framework, where this article was introduced that in any case when measures are being taken, fundamental rights have to be taken into account. And this article was a intervention mainly driven by Parliament after several attempts to put 2 or 3 strike into telco regulation and to increase the liability of internet access providers. And next slide. And this is not just one thing happening. There's also a lot of jurisprudence now being developed by both the European Court of Justice and the European Court of Human Rights, which clearly indicates that when it comes to copyright enforcement and copyright in general, and when it comes to blocking websites, that fundamental rights have to be taken into account. Next slide. We also see that this more critical approach tends to become structural. European Parliament, national parliaments, governments have clearly expressed opinions when it came to issues like ACTA or the extension of the enforcement directive, and you see clear hesitations when it comes to 2-3 strike approaches. The Dutch are an example, but also in Germany, for example, last year a report was presented to one of the ministries analyzing 2-3 strike and notification regimes, and actually since then nothing has happened. There was quite some outcry of saying that this was maybe not the right way to go forward, and you can of course imagine that with the upcoming elections in Germany, and we have seen earlier examples, these topics are not the topics that will help you win an election. So that's maybe also an explanation why in Germany things are going slow. France was mentioned. I have to say I was really surprised by the Lescure report. I can't say my French is impeccable, but I can read French without any problem, so I'm probably one of the very few Dutch persons who read all these 450 pages of the report. It's interesting. They should do what we do with most of our research, translate it in English. I wouldn't say that it's a total... that it's totally... Okay. No, go ahead. I have 2 more slides, that's it. Yeah. I'm not going to say that the whole HDP thing turned into a disaster, but I think it's very good to read the report, because it also makes clear that you should never follow an example from another country if you don't know whether that example turns out to be a good example. My final remarks, slide 27. In my view, for future policy development, leading principles should be better understanding of the facts. We need data, and even more than we have already, and it was stressed, it was underlined again by Ofcom. I think that's the right way to start approaching these issues. We need awareness of fundamental rights, and in this context, proportionality is necessary. And there's a last remark on my side. Value chain approaches might also be very helpful, to look not just at one particular player and see a player in the value chain as a bottleneck and use that player as a point of fixation, but try to look at the broader picture. And you know, I'm from the Netherlands, and maybe the most famous soccer player in the Netherlands is Johan Cruyff. And he's a kind of prophet. He says things that nobody understands. My personal prophet and philosopher is Yogi Berra. He's a former quarterback of the New York Yankees, and this is my favorite. You've got to be careful if you don't know where you're going, because you might not get there. Thank you.
Thank you very much, Nico, for your enlightening talk. And now we are in perfect time, and we got maybe 10-15 minutes of questions to our speakers before opening the other panel. Questions to our speakers from the floor? No, there is a question there. Come here.
Do you have any data about the cost of the Adopi in these years?
Well, the budget of Adopi is about 10 million euros. That's the data.
How much?
10 million euros.
10 million euros.
The budget of Adopi is about the budget.
All this year.
No, 1 year. The budget it's about 10 million. Yeah.
For the questions, I think you got a microphone on your desk, so you can use the microphone on your desk to put the question, please.
Can I go ahead? I just wanted to complement what I said in the beginning in my presentation on evidence-based policymaking, because our US colleague explained the IP-intensive industry study that the US made, and I just wanted to announce that we're working to copy. We're copying you, actually, this for Europe, and we're working together with OECD, the European Commission, Eurostat, but we're also working with the United States because we want to use the same methodology in the first step in order to have a comparable photo, which will be very important when it comes to international cooperation in these matters, but also important when it comes to what we really want to achieve with the free trade agreement discussions that that you've mentioned as well. We believe that our study will probably come out in the summer and will be presented, so we'll have two photos to be able to compare. But what we will do in a second phase, and that comes back, Nico van Eyck, to your idea of value chains, is to drill down more and have a second set of studies which look at how does IP change the success or not of an individual company in these different sectors, and what are the key factors that make it successful in terms of resilience to risks, risk-taking, getting capital, finding capital, and creating jobs and creating, the high-end jobs, creating good jobs in Europe. That will be the second phase, and we'll have that for the end of this year. Thanks.
Thank you very much for the comment. Are there other questions from the floor to our speakers? Please, use the microphone.
Yes, I have two questions, one for Professor van Eyck, which would be, in your research, did you consider the role of advertising and advertisers? You mentioned that enforcement may be temporary because violation moves on to other sites. But it seems to me that there is also the possibility that if you target the end users of the mechanism, it may be more permanent. So the question is, are you looking at advertisers? Mr. Cuervos, I was surprised to see that you also have an administrative agency like France and we consider involved in enforcement. My question is, when a decision is reached, and you have reached decisions in many cases, the recourse would be to an administrative tribunal or to a civil court?
Yes, we have looked at the role of advertising, but a little bit differently than you're implying, but I will also get into your question. In our second study, we noticed that free content is becoming a quite important part of the business model of the Internet. Free content normally exists because, well, of course, it's never free. It's supported by advertising. So it might well be that advertisers are becoming more aware of the fact that they, on the one hand, are supporting a legal model, but at the same time that they might be involved in non-legal activities, and that would then actually only make their business model less likely. The other thing is, I suppose you're referring to what others have mentioned, follow the money strategies. This is not a public meeting, so I can say that I once in my life started as a radio pirate and then saw the light and was at the basis of creating community media in the Netherlands. And in order, because, and when we had the alternative, so this is almost the same as what we're now having with developing new business models on the Internet. When we had this business model put into place, we also had a legitimate reason to fight what was left in the illegal environment, and there we used this follow the money approach. So advertisers were harassed, the people behind the activities were not only prosecuted because they were illegally transmitting, but there was also a link with, for example, all types of fraud. And so this overall approach, where several agencies and several ministries get involved, is definitely an approach that where I have had a personal experience that it did work. And it's what I always tell my students: if you don't know the answer, follow the money. It's the easiest way to find also the answer to a legal question.
Thank you, Professor Van Eyck. Carlos?
Thank you. All right. First of all, I would like to say that Section 2 of the Intellectual Property Commission is not exactly an agency. It's an organ of cooperation between 4 ministers taking decisions. And getting to your questions, well, in most of cases, the illegal content is taken down just after the notification. So in those most of cases, the procedure is filed. But I would say it is sleeping, preventing the case of a reinitiation of the illegal activity. In that case, if the illegal activity would be restarted, the right holder can go to the Commission and ask the procedure to continue. But until now, most of the cases are filed because there is a voluntary taken down of the content. There has been 4 final resolutions because in those cases there were not a voluntary taken down when the Commission makes the first notifying. In these 4 cases, with a final proper real resolution, administrative resolution, the resolution provoked the taken down. It was not necessary to go for judicial approval of the resolution, of the administrative resolution. And exactly getting to your question, the appeal to this resolution is purely judicial. Is a purely appeal to the judicial organ, to the court. Thank you.
Thank you very much, Carlos. Are there other questions from the floor? Please, I forgot, you have to spell your name and affiliation first and then make the question. Professor Prosperetti.
I have a question for Madame Jacquet, Eugenio Prosperetti, Università di Siena.
You mentioned the role of Adopi in enforcing DRM interoperability. I know that comes from the DADSI legislation. Now, I'm curious if that is something you still often use that power or not, and if this is regarded in France still as one of the fundamental pillars of promoting digital content, or if it is something which is not used so often, and how does some comments about that? Thank you.
So, no, it hasn't been used a lot. Actually, we just rendered one opinion on that matter. As I was telling you, it's the legal provisions are very complex to implement, but as concerning pillar, yes, it is a priority. It was a priority for Adopi, and in the Leicester report, it's very clear because it participates to the idea of finding a balance between rights holders and the consumer and the public, and make sure that the legal offer is attractive. Otherwise, there will be no alternative to piracy. So yes, in the Leicester report, and we'll see again what's going to happen on the basis of the Leicester report. But it's very clear that it's a priority, really. So I think France will stick to this priority, and it will improve the legal framework so to find a better balance. Thank you. And since I have a speaker, I just could I ask who's the person who asked me the question about the budget of Adopi? Because I didn't have the chance to know. Yes.
Marco Pierani Altro Consumo, Consumer Association.
Okay. And I just wanted to tell you that this year the dotation, the dotation has been reduced to 8.5 million. So, 8.5 million. So, this is as a part of the efforts that all the public authorities must make.
Okay. Thank you very much, Sarah. There is time left for one question, or one or two questions more. Don't worry. Prego. Use the microphone, please.
Good morning. My name is Paolo Marzano. I will be panelist this afternoon, Comitato Consultivo Permanente per il Diritto d'autore. I have a question for Professor Van Eyck. If I'm not wrong, you've said that according to your surveys, infringers also are great consumers of legal goods. Is that correct? How do you get to this conclusion?
That's mainly a question about the methodology of the survey. This is done by just asking people what they have bought in the last last year. It's a similar methodology, if I'm not mistaken, as Ofcom has used to come to the conclusion that those who download are the more active players in the market and are spending much more than those who don't download. So,
if you don't mind, did you double check this answer in other empirical basis? Did you see from the industries an increase in the consumption and sale of legal goods, or do you only stick with the answer of an infringer?
We, as far as the music industry is concerned, we look more closer to the music industry, and this is where we could see that if you take a broader definition of the music industry and you include, for example, concert and merchandising, that the negative financial effects were almost not there, or much more limited. So the traditional industry suffered incredibly. There was a loss of 100 million, if I'm not mistaken. But in other parts of the sector, if you again include these other types of services, they more or less compensate that downside. So, and the methodology that was used to check with the consumers is a traditional methodology, I was told. I mean, again, that's what the sociologists did, but it's a typical methodology where you ask, did you buy something in the last half year? How much did you buy? And they then weigh that, and somewhere at the end they conclude, and I have to believe them when they say that there is this effect. But again, this research was one of the first. It was challenged, and other research was brought into play and gave the same results. And you now see more and more research, like the Ofcom research, that links those who download with those who also spend money. And it's for an obvious reason. to some extent, because those are the people who are most interested.
Thank you very much. There is a very last word from Campbell on the same question, and then I have to close the panel. Campbell, quickly, please.
Thank you very much. It's really just to say that the finding that those who infringe the most also spend the most is also a result that's come out from industry studies that have not been published, which we have seen. So it's not only coming from research that the Dutch and people like ourselves have done, it's also coming from the industry itself.
Okay. So thank you very much. A show of appreciation for our guests. Thank you very much. And we can go quickly to the second panel. And I call here Maurizio Menzi, Eugenio Prosperetti e Angelo Zaccone. Grazie.
Thank you.
That is the weekend. And then we received a follow. I received a phone call from the person saying.
cancello.
Perché poi dobbiamo mettere...
Posso richiamare all'ordine l'audience? Dovremmo ricominciare per il secondo panel della settimana, della giornata.
I would like to invite our guests to please take their seats so that we can start the second panel of this morning session. And I would like to call the meeting to order so that we can begin the second panel.
Allora, abbiamo sentito nel panel precedente.
Now, in the previous panel, we heard the opinions and the various experiences around copyright enforcement in the UK, France, Spain, and the Netherlands. Now, instead, we will open up, or we'll have a discussion after having heard from three experts, Mr. Menzi, Mr. Zaccone, and Mr. Prosperetti, who in a brief presentation will share their vision as to the most salient aspects of this problem. And they will, of course, consider specifically the situation in Italy, which, as you know, is quite different from the situation of the other countries, or described in other countries. Peculiar is the position of the authority for communications, which holds or has a role quite different from that of the respective authorities in the other countries. I'd like to immediately give the floor to Professor Menzi, who teaches communications law at the Luis Guido Carli University. So, Maurizio, thank you for being here.
Grazie, Presidente.
Thank you, Mr. Chairman. Yes, I'm going to actually focus on enforcement. And in the light of the presentations that were delivered by the previous speakers, I think we might safely state that our position or our situation is rather fragmented and diversified. And this in spite of the fact that the Directive number 48 was enacted in 2004. Now, I think that what happened was that the Commission was late in acting. I mean, it's true that copyright, as we all know, is the exclusive, or the enforcement is exclusive to the individual member state governments. However, because of the Internet, this principle has been overlooked, and I think that we could have readily expected a more timely response on the part of the European Union. Instead, as observed several times this morning, there is broad copyright protection occurring at different levels, the EU level, the international level, and the Universal Declaration of Human Rights. And after all, it is part and parcel of human rights, as recalled recently by the Human Rights Court in the Ashby case dating back to last January. Anyway, Directive 21 also points out, or 29 rather, points out that any harmonization of copyright and related rights must be granted a high level of protection and enforcement. However, provisions influence the domestic market. And although the European Union doesn't have a competence, exclusive competence when it comes to the protection of intellectual property, it does have that power when it comes to regulating competition. Now, we know that various member states are using a panoply of instruments which is jeopardizing the appropriate functioning of the domestic markets. And this situation certainly does not encourage free circulation, as acknowledged by the European Commission itself. So, in essence, because there are different national legal systems, there is less the protection of intellectual property. Now, as observed by the Commission in the report of December 22nd, 2010 on its enforcement, Directive 2004-48 was not made to meet the challenge posed by Internet. There are many other issues that should have been examined in greater depth. For example, as we all know, from 2004 to the present day, crime on the Internet and copyright infringement haven't gone up, especially online crimes have become multi-offensive and have damaged all the stakeholders. We know that this has been an increasing trend. It's increased exponentially. Also, and partly thanks to the fact that certain criminal organizations have decentralized or have relocated abroad, so to speak, and have set up headquarters and shop in areas outside of the EU. Thus, measures and procedures and any remedies provided for by the directive should have been effective, proportionate, and should have been able to exercise a deterrent effect, but instead have been slow in countering this problem. The 2010 report dramatically has shown that the disparity between the systems existing in the various member states to ensure respect and enforcement of intellectual property rights undermines the appropriate functioning of the domestic market and weakens the enforcement of the law in this area. Now, there have been different interpretations and different practical applications, and the result of that is that we're faced with great fragmentations and obstacles to cross-border activities. There's been a loss of confidence in the domestic market and lower investments in creation and innovation. And the Court of Justice has recently shown that because there's no harmonization at a European level, member states are not authorized to place restrictions to trade based on their national laws, although this is actually happening. There are key aspects that need to be harmonized quite urgently, and they're listed here. One, the use of provisional and other measures like injunctions and orders, procedures to collect and preserve evidence of violation and infringement, and various corrective measures, including the modes and methods used to compute compensation, improvement of access to courts, and clarification of the responsibility and accountability of the individual players. As I said before, a late and inadequate EU intervention to protect copyright jeopardizes or actually runs the risk of compromising trust and confidence in the effectiveness of rules. And there's been a doubt instilled in people which any intervention could actually challenge the neutrality of the net. And this is something that we need to dissipate as soon as possible, because we know that freedom and is essential here. We heard from the Director of the European Commission, and we know, therefore, that the Commission has set out for itself a very ambitious roadmap. And this has been done through intervention that will necessarily have to be hinged on the directive on e-trade dating back to the year 2000, the directive on electronic commerce, actually, which is number 31. And we also know that notice and action procedures must be followed by others aimed at internet providers. So what are the goals? Well, of course, these goals are ambitious, they're far-reaching, and they were set out by the Commission. more recently in the communication it delivered on the contents of the digital single market of December 2012. The Commission stated that in 2014 it will decide whether or not it will submit legislative reform proposals. I think it's late, though. And recently, two consultations which started in 2012 on the clean and open internet and on civil enforcement have just been concluded. So we're dealing with not a very comforting picture when it comes to the European Union or the Commission, especially the late interventions are to be regretted. And instead, to offset that, domestically, the legislative framework is much more structured and it's much clearer. So Article 182 bis of Act 248, we know, attributed or entrusted the authority with oversight and inspection powers. Under Article 32 bis of Legislative Decree number 44. And this contributed to a more structured situation locally, along with the Legislative Decree number 70, which introduced a twin track for administrative and judicial protection. So I think that the picture is now complete, because the previously quoted regulations have, or provisions, have indeed provided for the enforcement of online copyright and provide a sufficient and adequate legal bases to legitimate intervention, an accurate intervention on the part of the authority, including the possibility of resorting to inhibition and inhibitory powers. But the action of the authority in this regard is not discretionary, in the sense that the authority sometimes is unable to carry out quickly the intervention required by the legislator. And because of this, it might expose itself to omission. And so that's why I think that maybe we should not invoke the whole theory of implicit powers, because here we're talking about very clearly regulated powers. I think that the question is the way in which the intervention should be carried out. Whatever intervention is taken up, it will have to be evidently proportionate and respectful of the suggestions provided by, and insight provided by, recent EU jurisprudence and the details of the constitutional charter. Thank you, Maurizio. I will now give the floor immediately to the second speaker, Mr. Prosperetti, who teaches competition law and regulation at the Department of Economics at the University of Siena.
Grazie Presidente. Il ringraziamento all'autorità per l'organizzazione di questo importante seminario è d'obbligo ed è un piacere porgerlo. Nel mio intervento vorrei sottolineare due criticità delle proposte che si possono studiare per la tutela della circolazione delle opere digitali, e anche fornire due spunti per la soluzione delle criticità da me segnalate. Io mi sono basato appunto sull'analisi delle problematiche relative a due affermazioni che si sentono nel dibattito. Il primo è che bisogna o si può intervenire sulla rimozione delle singole opere in violazione del diritto d'autore, e la seconda affermazione è che si può costruire un intervento basato sul colpire i siti pirata. Passando alla prima slide, quella con la giurisprudenza, vediamo che abbiamo io ne ho scelte due, ma questo tipo di lavoro si può fare su molte sentenze che riguardano il diritto d'autore digitale. Vediamo per esempio nella sentenza Pirate Bay si parla di un titolare del sito web che non detiene mai l'opera protetta e quindi di una configurabilità del reato di messa a disposizione del pubblico attraverso internet, anche se queste opere in realtà non si sa dove sono, e bisogna quindi passare per il procedimento penale, cioè in questo caso un intervento veloce non sarebbe forse possibile. Se vediamo nella sentenza Sabam Scarlett vediamo che il filtraggio preventivo di cui si occupa la sentenza serve, l'ultimo bullet, ad identificare nella rete di un fornitore i file contenenti un'opera musicale, ecco, contenenti un'opera, cioè non esiste nella normativa, se vediamo la slide successiva, una definizione di opera digitale. Non esiste cioè un passaggio che ci porti dalla definizione tradizionale di opera tutelata, di opera dell'ingegno associata ad un supporto che si fissa in un supporto, che ci consenta di capire in maniera agevole e con l'agilità sufficiente a un procedimento amministrativo quando un file contiene effettivamente un'opera tutelata dal diritto d'autore. Occorre sempre un'attività di verifica, di capire qual è il formato del file, se quel file effettivamente rappresenta un'opera, in che termini, a meno che non sia un file tutelato dalle misure tecnologiche di protezione o che contiene informazioni sul regime dei diritti. Pensiamo a una fotografia digitale che non sia nella rete senza un watermark, senza alcuna informazione su chi è il fotografo. La normativa sul diritto d'autore ci dice che dovremmo guardare il retro della fotografia, le fotografie digitali non hanno un retro, ma questo è l'esempio più semplice che posso offrirvi con la sinteticità che caratterizza questo intervento. Allora, come si può fare? Beh, un esempio ce l'abbiamo, l'abbiamo anche sentito stamattina, è quello che ormai funziona da anni negli Stati Uniti, quello del DMCA, nel senso che il problema è stato risolto lasciando fare al titolare dei diritti che cosa? Una dichiarazione in cui si assume la responsabilità non solo di segnalare, ma anche di fornire al destinatario della segnalazione tutti gli elementi necessari a verificare la segnalazione, nonché una cosa molto importante, un'assunzione di responsabilità per quanto riguarda la veridicità della segnalazione stessa. Io considero problematiche le proposte che prevedono una segnalazione ad un ente terzo, a un provider, a qualsiasi destinatario, che sia semplicemente una segnalazione e che poi debba essere gestita e preveda attività di verificazione dell'opera digitale, perché queste sono complesse, prevedono l'uso di risorse che a volte non esistono risorse centralizzate per il controllo del regime dei diritti.
Only the rights holder has the true knowledge of how those rights have been granted and can make statements, taking the responsibility for those statements. And there also has to be the right to reply to these statements with a system which the DMCA does implement. We've heard that it's not the ideal, but it is something which does work. So therefore, any notice must be supported by a statement of responsibility, and individuals shouldn't be left to deal with these issues on their own without it possible for them to decide whether they are faced by a work. And so let's move on to pirate websites. Often it's said, if we just close down these sites, we get rid of almost on the online piracy. The fact is that these websites don't have a clear legal definition. You can actually say they don't really exist in legal terms. If we look at the way that they present themselves on the network terms and conditions, the services are self-declared as legitimate or very similar, dangerously similar to websites which carry out legitimate activities. Only by analyzing the situation at length, so which would rule out rapid solutions, do we see that there's a very dangerous border and the category of pirate, which is very difficult to discriminate between pirate sites and non-pirate sites, because we have to speak about storage services, indexing services, file sharing services. So what are the features of what we could call a pirate website? I think it would be a refusal to trace their users in any way. The refusal to know who the uploaders are, the refusals to know who the downloaders are, and the refusal to know where they get money and where their money goes. There are three categories. They may have registered users, but you can register with any name, even with a fake email, and without any conditions. Anonymous downloads are allowed, and as far as monetary interaction is concerned, any kind of payment is accepted, and nobody asks questions where this money comes or where it goes to. Could be said that it's legitimate to act anonymously, and this should be protected because the material which is hosted, shared, and offered may have importance, political importance, and make it possible to spread information which would not be made available in other ways. This has already been raised. However, this is not an obstacle here. We're not speaking of preventing activities. We simply want to establish a system of responsibility and liability. For example, if a broadcaster sees reports coming in through their own network, and then they decide whether there's any responsibility on the part of the individual who acted, or to shoulder the responsibility themselves, protecting their own organization, considering that the activity carried out was justified. So if it decides that users are anonymous, this obviously means that they are taking responsible. So I think that we should not speak of pirate sites, but sites which take on responsibility because they decide not to know anything about their users. In the current economist regulation, the legal basis for an approach of this kind already exists, even though a number of things have to be found, because Article 15 Paragraph 2, which speaks of a reporting to the authorities information which makes it possible to define the identity of the users of their services. And we also see, and this is something which is very well known, that the performing party does not have available the services if they can be connected to the recipient of the services, but the person providing the service, if he doesn't know the consumer of the service, obviously the consumer of the service does not exist, and therefore this is not applicable.
Il fischietto rosso, ma mi pare che più o meno la temporizzazione era assolutamente perfetta. Grazie Eugenio.
Thank you very much, Eugenio. And now I would like to give the floor to our third speaker, Mr. Zaccone, who is the president of the Italian Institute for Culture Industry, and he's a great expert when it comes to cultural policies, media policies, and he's very much involved in copyright protection issues. Thank you. Of course, if you're interested, I refer you to the written text. I'll just make mention of a few highlights, and all of this information will be posted on the site of the authority. And perhaps I'll be paving the way to the presentation that will be made by Mr. Martuscello, the Commissioner. What emerged from the discussion this morning, I don't want you to think I'm clairvoyant, but it pretty much reflected what we've written in this report. We're independent and we're quite critical of AGCOM's activities, which we think is speaks highly of the degree of democracy that we uphold. We're not as critical as Mr. Scorza, but we're sufficiently so. As was said by the Director General of the Commission, Ms. Giorna, this morning, I think that there's great interest when it comes to the legal approach to these questions. Instead, I think we need to look at a more general overview. We need to look at the economic and sociological and other implications. So we need to look at the broader and wider context. Piracy and copyright are phenomena that perhaps might have been unpredictable 20 or 30 years back. And the discussion and the debate constantly reflects this dichotomy between two ideological rather than technical and scientific poles. There is a demonization of, we have cruel capitalism on the one hand, and on the other hand, you have pirates and free riders. However, what seems to prevail amongst the general opinion is what prevails is the tendency to criminalize those who wish to protect copyright. In the group of those who think it's not just a cultural issue, but a political one, we have a person who sees the Internet as being a savior, a panacea. Then there are other players, obviously, who think differently, and these include Google. We believe in jest that in the media policy, after years, we see the reproduction of the myth of manna. It would seem that the new produces a revolution, but this is something that concerns the Italian situation specifically. Take local TVs. Before that, we had VHS. Then we had terrestrial digital television. There's like a multiplication of pluralism and wealth. But this is a procedure that very much conjures up the past. And all this, piracy becomes almost politically correct because it's the new vis-a-vis the old. Now, Google did something a couple of years ago with a very accurate communications operation. It asked a Boston consulting group to do a national survey, and which was taken up elsewhere throughout the world to try to quantify the extent to which the Internet contributes to the domestic economy, to the national economy. And most media gave their input here. But more recently, research was done, it's called, or by Masnick, who founded Technivert, and he wanted to explore the social aspects. This research was translated into many languages, and the purpose of it was to show, and I'm going to skip to slide number 4. This recent research stated that books are fine, and the cultural industry seems to be absolutely prosperous. Now, any sociologist or economist can show whatever he wishes, but I can tell you I've seen that more books are published today than ever in the past, but the turnover is declining. Take music. The music markets, live music markets are growing, and this is true, definitely, as stated by the representative of the EU or Commission. It's true that live music markets are growing, as is digital music. However, objectively, in the past decade, the overall turnover of the world and European music industry has dropped by 50%. So even when some say that there are positive signals pointing to a growth, I don't think that they are to be seen optimistically, because they're very minor signs of growth. I really think that there's a deceitful mantra here, because people use the slogan that says that the net is free and the net produces freedom and wealth, and copyright is instead something that constrains that freedom. Now, let's go back to Google and what it did with Boston Consulting Group. A few months ago, WIPO did something quite interesting and intelligent, but not strong enough, because it tried to show the weight in percentage terms of the copyright industry. It's as if there was a competition between the internet and the copyright sector in terms of which of the two seems to produce more turnover. So internet produces 5% of GDP. Instead, according to this recent studies, creative arts account for 6% of the GDP and 6% of all jobs. Let me now just refer you to an essay by Levine that was published a year and a half ago. It's called Free Rider. And in a very eloquent manner, the author shows that we are witnessing an overall impoverishment of the cultural industry at large. A year and a half ago, we implemented a project which has produced results that are useful for everyone across the board, even those that are against and enforcing copyright. We showed that in Italy, on the whole, the cultural industry and all of its sectors are registering constant declines. They're losing turnover. They're losing jobs. And this is a fact. And I think that public reflection hasn't dwelled on this far enough. Neither has the institutional reflection. Now, these findings, as far as Italy is concerned, I think state that it is absolutely necessary for the public institutions to step in. Yesterday, the minister in this very room announced a great prospects to cure the illnesses of the Italian cultural sector. But Minister Bray took a very sharp, a very clear position vis-à-vis the copyright enforcement and pointed to the French model as the beacon to follow. Let me now move on to my conclusions. Actually, I don't have the time, so I'm just going to read something. It's necessary to promote awareness of consumption, because a lot of users have no idea of what they're consuming. That emerged clearly in the presentations this morning. Then I've already mentioned the ISPI research or survey, which showed that in the past 5 years there was a 5% loss of turnover. But in the U.S., in 2012, according to another survey, unemployment in the publishing industry increased by large unemployment levels. 30% of American journalists lost their jobs. All of these, I think, are important signs that need to be considered. Finally, what I'd like to conclude with is that while the European Union asked RAND to carry out a survey to quantify estimates on the loss of revenue and the loss of labor force because of piracy. And I'm surprised that the woman from the European Commission didn't do this. Also, it's interesting to reflect on what was said about file sharing. It's true, but it doesn't really determine an overall improvement in consumption levels. I mean, these findings are interesting, but I think we need to look at them in a broader context. Now, about models of reference and benchmarks. We've conducted studies all over, and we think that the Hadopi model is quite effective as a response, a gradual response model, but people speak of Hadopi as if it were a piece of legislation killing all sorts of freedoms. Now, she mentioned annual data. Instead, we have data covering the past 3 years. 3 million users were identified, 1,550,000 notifications were sent, and 340 files were opened. 14 were sent to court. But one thing that she neglected to say, but that I found in Hadopi sources, is that 90%, well, there are different estimates, but between 80 and 90% of those who received a second notice practically stopped piracy activities, or almost. Let me just conclude by saying that we believe that we need timely warnings to be sent out as a deterrent to users. I think that this is the best way to remedy the situation. As concerns Italy, I smiled when the representative of Ofcom talked about the fact that legal proceedings are now no longer taking 12 months, but 2 months. I was smiling because I wish we had that track record, because either something is sped up or we're going to really collapse as a system. According to an objective analysis, we believe that Hadopi is a good benchmark to focus on at a European level. And when anyone criticizes this position, and says that this kind of mechanism costs 8 to 10 million euros a year, well, to that I can respond by saying, yes, of course, that is an expense. Nevertheless, let's look at the benefits in terms of the loss of revenue at a national level that is created by piracy activities. Thank you. I'm afraid we're running out of time.
So there's 5 minutes for questions, and then we have to move to the final statement. So any questions from the audience? Please give us your name and affiliation, please. Marco Cialdoni, I'm speaking on behalf of Altro Consumo. Just a couple of comments. The first one, just questions, please. We have very little time. Questions and comments. The first one is on the powers of intervention of the authority, where you mentioned Legislative Decree 2003. Since, as everybody knows, those provisions don't indicate which authority is competent, I would like to know where it's indicated that AGCOM has the overall responsibility for intellectual copyright protections. I give the floor to the two lawyers. And the second point is in relation to the data which have been quoted, especially the last one, and Adobe, and the fact that 90% stop having illegal contact after the second notice. I was interested in how this was calculated. Did they monitor the whole online activity of a given person, or were they no longer checked? First question will have Maurizio Menzi and then Eugenio. And Angela will be the second to answer. Maurizio. I quoted the legislative decree because it introduces the dual track procedure. First, the administrative authority. The administrative authority is undoubtedly AGCOM, It seems very clear to me. The Commission, I think, referred to Articles 14, 15 and 16. I don't have the article before me. But in addition to this, there's a very clear fact that the administrative authority and AGCOM also has the power to intervene. So a dissuasive authority which it has and which it should use. Eugenio, any comments? I said something which is based on the directive which speaks of the competent authority in general, which leaves it to each country to decide on its competent authority. It could be the judicial authority or the administrative authority. The only comment I think I should make is that first of all you have to identify the measure and then you see how it should be implemented. AGCOM would certainly be the responsible administrative authority because the decree speaks of electronic communications. But we have to, I think it says vigilance and oversight over these activities. And if the type of activity is not defined, we can't really see who the competent authority is. Angelo? From the report, it was done by monitoring the intensity of traffic of users. Now, all of the people in the room know that this is an indicator, basically, a priori. I just wanted to say something which I referred to. Top-down mechanism through an authority or a self-regulating mechanism through agreements with the service providers. We can think of the American model, which is starting up and which involves a monitoring done by the service providers. I remember a statement I made before the 8th Commission of the Senate said that 70% of our traffic on network is video. There was obviously the problem of the density of bandwidth used because of pirate consumption, and 50% of that is peer-to-peer, and it's made up by two applications, eMule and BitTorrent, which are used exclusively to download films from the network. So I think that's very clear. Angelo, coming back to the question is relevant. There's no doubt that education works on the network. I am very convinced of this, but I think the computation there is topical, and it's a discrete one, because you go and look at the website where the illegal activity was undertaken. I don't think that you could check the whole of the activity of a user, so that means that they don't go back to that website. But I would say that certainly a large part of the users will be dissuaded. Sorry, the microphone is coming and going. It's now gone. Got one time. We've got time for just one last question.
Sono Filippo Sarzana,
Philip Sarzana, I'm a lawyer, and I wanted to ask Mr. Menzi today, the AGCM, which has reported to Parliament on copyright and asked for the legislature to act activity. Why is the AGCM referring to Parliament and AGCOM decides to act autonomously? If your responsibility on copyright is so clear, why is it the HCCCM, which has also decided to take action on this issue?
Maurizio, vuoi rispondere?
Io mi avventuro in una risposta che evidentemente...
Well, I can stick my neck out and try and give an answer. Obviously, there's a constant interplay and dialectics between authorities. That's something which is happening for years, and the issue of consumer protection is a very clear example of where there have been these debates. and also disagreements. Sometimes disagreements have been quite heated. I've simply set out my opinion and said that I believe that regulatory power is very solid, and it's based on a number of provisions which make it absolutely crystal clear. And I went as far as to say that I believe there's power which should be exercised. The battle will be on the ways and means of this activity. But personally, I have very little doubt about these powers, and I think that I'm in good company in that opinion. The fact that the authority for competition in the market think that Parliament should act is something which is actually something which is welcome. I think it's always important for the legislators to take action on subjects of this kind, but we can't wait for the legislators to act in addition to what the legislators have put on our plate, because I think this would be a waste of time for the market and for the consumers. Thank you, Maurizio.
Il panel, ringrazio
So I've got to end this panel discussion. I'd like to thank our three speakers. I think that the issue which was raised by Mr. Serzana can be discussed during the afternoon workshops, where the aspects... Yes? Got another question, but I'm afraid we don't have much time. Just a statement, actually. Just wanted to reassure Serzana. Agicom were dealing with another problem. We'll discuss that this afternoon during the Pastoraro Bredo workshop. So there's one profile of interest on the part of that authority, and we have a slightly different area of interest. Thank you. So I'd like to call on Mr. Martuscello, Agicom Commissioner, who will be winding up.
Allora, se riprendiamo posto, così diamo la parola per le conclusioni.
Let us now give the floor to Mr. Antonio Martuscello, the Agicom Commissioner. Of all Agicom commissioners, he's the one that has the most experience in the area of multimedia contents. So it is with great pleasure that we welcome him and that we prepare to listen to his concluding remarks on the whole question of copyright of digital work. Thank you for your friendly words. First of all, I think that copyright is a topic that's always inflamed passion. Giuseppe Verdi, in a letter to his editor Riccardi, recalled that protection of human right, of copyright, actually saved him from the bondage of actually writing to survive. He could finally spend his time doing what he liked. Others often have discussed this and deemed it to be a crucial issue in the development of human rights. So it's a very good thing that today we are openly and frankly discussing the matter, and that we're talking about a freedom on the web and copyright with full cognizance of what is at stake. The purpose of this workshop is to reflect together within an overall context as to the most appropriate solutions to be adopted and implemented to enforce copyright in the digital environment. We're dealing with a very complex system, as recalled before, that was triggered by the digital revolution, which brought about great changes in the media world and in the communications world. Digital technologies allow for a perfect replication of contents at costs that are next to zero. And the increase in the capacity of telecommunications networks, their interconnection and multimedial terminals have stepped up the pervasive nature of these contents. In the digital environment, any product can be replicated. And the distinction between the original and the copy, it disappears or tends to disappear. So when the copy becomes the same thing as the original, the perception of the difference by the user vanishes. And today consumers are not really fully aware of which products are real and which are counterfeited. Analogically, instead, products were disseminated over the net and the support, which involved a differentiation between the medium and the content. Today, instead, the same content can be provided across different terminals, and access to the content is not secured in a given spatial and time context that needs to be determined beforehand. Instead, it's something that's determined ex post on the basis of the needs of the users. And the end point here is that the famous paradigm, anytime, anywhere, on any device. Hence, the enforcement of copyright was based on the historic determination or identification and differentiation through content and medium. Now, instead, the digital content, as we see it, is being spread beyond the medium that was traditionally used to convey it. And the traditional forms to protect copyright are no longer effective. Hence, the old tools and instruments need to be reviewed and rethought, because the Internet has, of course, revolutionized our daily life. It's become an instrument, an extraordinary instrument of democracy. It's a way for citizens to exchange their views and opinions, and this modern agora has to be preserved and furthered. But the network is also a market. It's a place that where goods and services are sold, and it's fertile ground for illegal trade and commerce, which can undermine pluralism and the freedom of expression. And piracy, unfortunately, is jeopardizing intellectual production as the whole industry, including entertainment. The digital revolution, as any revolution, brings about opportunities as well as risks. One risk is the deterioration of professional information, because it's difficult for editors to remunerate productive factors. Or in an even worst case scenario, the whole industry might collapse, and there could be even less pluralism of information because it may be concentrated in the hands of some. Instead, if we look at the opportunities, today technologies can, of course, serve as an amazing tool of enrichment thanks to the multimedial contents of information. This is a great business opportunity for businesses that will be able to grasp the or meet the challenge. But there has to be fair competition in this market, and there has to be there have to be sure and certain copyright enforcement mechanisms, especially if we're talking about intangible assets like film and music and digital communication. We need to definitely make sure that one gets what one has paid for. We mustn't take away resources, of course, for the production of the creative industry. The right of creativity and the right to free expression cannot be opposed. Protecting one does not mean going to the detriment of the other. And as Professor Zaccone Teodosi said, the best way to counter piracy is still under discussion. There are many solutions proposed. and many players are involved. We must, of course, contemplate many actions, provided that they are within the panoply of instruments made available to the authorities, so orders and injunctions, just to mention a couple of them. So we mustn't only think about protecting the author to the detriment of the user. Instead, we have to find a model of regulation that will strike a balance between all stakeholders so that we adopt effective measures. But to do that, we must find the cooperation of all. Although no one should play the sheriff of the network. Everything has to be based on the respect of the right to privacy, to entrepreneurship, and to the freedom of expression. And any policy to combat piracy mustn't do without measures that encourage the legal offering of contents to citizens. We mustn't only focus on repressing the phenomenon, otherwise we're going to miserably fail. They would be misconceived by a lot of users. And I think that wherever legal offerings take root, piracy will decline. This was said by many. So an important point is that of education. Indeed, users have to be cognizant of the risks involved in illegal downloading of contents, and the fact that one downloads material and content at zero cost doesn't mean that there is a zero cost. There is a cost to it attached, and users have to realize that illegal content is like a Trojan horse. It looks like a gift, but it can actually wreak a lot of havoc. From viruses to the theft of identity, of personal identity. However, the action of public authorities should focus on being effective and efficient in their measures to counter piracy. They should also look into the proportionality of measures. This is the spirit with which we will try to tackle the problem. We will contribute to counter massive piracy and try to bring it down to a physiological dimension. Our goal is to punish the systematic use of other people's work. We want to be pragmatic in our approach, and we want to respond selectively to a pressing demand of the cultural industry, and we want to punish the professional violators or infringers, not those who make reasonable use of contents. We don't want to criminalize end users, nor do we wish to strike only one side or in one dimension of the phenomenon. We all know about the phenomena that facilitate the doings of global players, but the benefits that benefit legal players often benefit also those who operate in an illicit manner. The short-term goal that we would like to pursue is to counter this international oligopoly of piracy. As the European Commission pointed out, the transboundary phenomenon of, or nature of this phenomenon has undermined people's confidence in the Internet, which has jeopardized instead the development of the Internet, which could instead bring so many benefits. The representative of the Commission this morning said that the Commission is trying to harmonize enforcement measures and measures to develop coordinated and harmonized payment systems so as to increase the confidence of citizens in online transactions. Of course, this is complex, but the valuable contributions that we heard today should be harmonized, and on that basis we should be able to develop guidelines. These are just a few highlights that I think are important to bear in mind. Coordinated intervention on the part of regulators, number one. We must take a quick action because piracy is undermining the national industries, and this has adverse effects on the economy and on employment levels. Piracy doesn't only have economic effects, but it also has effects on the labor world. We must also protect our assets and the memory and the linguistic and national identity of the various countries. The U.S. in a report confirmed that Italy is part of the watch list as one country that needs to be followed closely because of piracy endeavors. AGCOM hasn't done much compared to the past, hence the need for a rapid intervention by the authority. And Mr. McCoy this morning showed us what the incidence of piracy is on economic transactions. These points mustn't be neglected. But how do we step in? Well, with balance. We need to strike a balance between the different rights at stake, the freedom of expression, the freedom of entrepreneurship, and privacy. Measures must be proportionate and they must be timely, because on the internet, the time is basically down to zero. We mustn't think in terms of days, but hours. Secondly, we must provide or promote twin-track policies. On the one hand, we must promote measures to foster legal offering of contents to citizens, but on the other hand, we must provide for enforcement activities based on international best practices. Both of these twins have to be pursued with determination and patience. The last point is the need to harmonize measures at a European level and the need for international coordination. We know how difficult it is to address such an important issue as this with instruments that are global. That's why this workshop is so important, and I'd like to take this opportunity to invite our foreign guests to work together, because through the network we can pool our energies, our experience, our skills, and we can also involve the institutions that we represent. We can combat piracy effectively only with a common enforcement effort internationally and European-wide. This is an appeal that I launched to you so that we can all join forces. Thank you for your kind attention.
Thank you, Antonio. I'd like to thank Mr. Martuscello for the conclusions, and you're all invited to a light lunch. We'll be resuming at 2:30 p.m. in two rooms. In the Culture Committee room, we have the panel which is headed by Antonio Pareto on online content, whereas in here we'll have Mr. Postarello with a panel workshop on protective tools. The lists of speakers for the two workshops are there on the tables outside, and you can add your name to that if you want to speak.
My sister often